May it please your lordship. Lordship, the petitioner is the father of a minor girl, lordship. Earlier by this honorable court's order, he was allowed to meet with the child, lordship. But the mother is not allowing him to meet, lordship. The effective order, your lordship will find at page 15. Page 15 is the order of this honorable court. Para 8, my lord. Para 8.
Heard, Mr.
R. Karim, my lord.
R.
Karim.
R. Karim, learned counsel for the applicant. This application under section 11 and 12 of the Contempt of Courts Act 1971, read with Rule 3 of the Contempt of Courts, Gauhati High Court Rules 1977, and Article 215 of the Constitution of India is preferred by the applicant for willful and deliberate violation of order dated 1/4/2026, passed by this court in FAO number 03 of 2026. Peruse the application and the documents enclosed with the documents placed on record, and also peruse the order dated 1/4/2026. Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks.
Can it be after 3 weeks, my lord?
Okay. 3 weeks.
Oblige, your lordship.
Items for orders, item 17.
May I please your lordship, step upon respondent number 1 through paper publication is complete, and respondent number 2 is proposed. So matter may be fixed for hearing.
Paper publication completed.
Completed.
Okay. Heard, Mr.
As shown on behalf of Mr. S. Datta.
As shown, appearing on behalf of Mr.
S. Datta.
S. Datta, learned counsel for the appellant. The learned counsel for the appellant submits that service in this matter has been completed and the LCR has been received, and also as such the matter may be listed for hearing. Accordingly, it is provided that registrar list the matter for hearing after it is 2010 matter.
28 July.
Short date.
21st July. No vacation. No vacation.
Before vacation if possible.
23rd June.
23rd.
Item 18.
Lordship, in regard to item 18, we are yet to receive instruction from the insurance company.
In 18, you work for the appellant.
Affiliate.
That was number 1A, 1B, and 1C.
So is there any chance for reconciliation or no?
But there is nothing done by the applicant.
Lordship, we are yet to receive any instruction.
Here service completed. Service completed.
Service completed.
And LCR has been received.
No. There is nothing.
Heard Mr. So-and-so, learned counsel for the appellant, and Mr.
And I can.
And I can learned counsel for the respondent number 1A, 1B, and 1C. Is there not reason now? Huh?
Judgment dated 29/6/2020.
It appears from the record that though the matter was admitted on 13/9/2023, the TCR has not yet been called for, and accordingly, it is provided that recusal requisition the record from the learned tribunal urgently, fixing the matter on. Copy fixed that before vacation.
19 June.
19th of June.
Item 19.
Lordship, in regard to item number 19, I am for the appellant. And Lordship, we are yet to submit our detective file, Lordship. We will submit it today.
Heard Mr. So learned counsel for the appellant. The learned counsel for the appellant submits that substitution application is being filed today, and he prays for listing the matter after 1 week or 2 weeks.
2 weeks, Lordship. 2 weeks.
2 weeks.
Published.
Item 20.
And for respondent number 1.
None appears for the appellant on call. However, Ms. Mazumdar, learned counsel for the respondent number 1 present, list the matter after 2 weeks. In the event of subsequent non-representation of the appellant, appropriate order shall follow.
21.
My lord, notice to the respondent number 2-3 is not served as per this court was directed to take step. My lord, so I may be request to take a dusty service.
Respondent number 2 and 3.
2, 3, and 4.
2, 3, and 4.
Yes, ma'am.
Madam, you are for respondent number 1. Heard Mr. Das, learned counsel for the appellant. Ms. Chaudhary for the respondent number 1. Learned counsel for the appellant submits that he may be allowed to effect service upon respondent number 2, 3, and 4 by dusty mode. They are allowed. After effecting service by dusty mode upon respondent number 2, 3, and 4, the learned counsel for the appellant shall file an affidavit to that effect before this court. Recessal is the matter after 2 weeks.
16 July, my lord. 16
After 16 July.
on the
After
16 July.
vacation.
On 16 July.
Okay. 16 July.
My lord, I have two matters in court number 16. So there is item number 28. Now 25 is going on. There is another matter 25 here. Can it be taken now?
Here's the item number
25.
No problem, 0. 20 to the next.
16 or that answer.
25 updated.
Yes. My lord, in this case, my lord, notice to the respondent number 1 and 2 is not awaited. And-
Lordship, copy of the memo of appeal is not, that time also it was
Madam, you are appealing for respondent number?
4, Lordship.
Four.
Natural.
Heard Mr. Das, learned counsel for the appellant. Ms. Mazumdar for the respondent number 4. Ms. Mazumdar submits that she has not been furnished with the copy of the memo of appeal. Mr. Das shall furnish a copy of the memo of appeal to Ms. Mazumdar within a period of
1 week, my lord.
1 week, within
Yes.
a period of 1 week from today. Office note dated 30/5/2026 indicates that notice upon respondent number 3 is served.
1, 2, and 5 is remaining to.
The said office note also indicates that neither ID card nor unserved notice in respect of respondent number 1 and 2 has been received. How many respondents are here?
5.
5, they have
Five.
not given any report, Lordship. For 5.
In
they have
respect of 5.
not- Yes.
Whether you have taken any step upon respondent number 5?
Yes, my lord, still not maybe allowed. Because of on earlier order, there was not reflecting the serving notice to respondent number 5.
5.
Yes, my lord. It was only directed to take steps of 1, 2, and 3.
Okay.
No, it is there, Lordship. Order dated 26/4/2023. Issue notice to respondent number 4 and 5.
Okay, you take a step then.
Okay, my lord. Okay, my lord.
Mr. Das submits that he may be allowed to take a step upon respondent number 5 and 6.
No, 5.
5.
One-
Respondent number 5. Respondent number 5. Accordingly, it is provided that press is that a step be taken upon respondent number 5 by speed post and also by usual process within a week from today, list after 4 weeks.
Highly, my lord.
Item 22.
Your Lordship, we took steps in 2023. However, unserved notice has arrived for R5 and R6. So we may be permitted to take fresh steps.
Upon respondent number
5 and 6.
5 and 6. You are for respondent number
1, 2, 3, and 4.
1, 2, 3. Heard Ms. Bihani, learned counsel for the appellant, and Mr.
Yes, Bolo.
S. Barua, learned counsel for the respondent number 1, 2, 3. Ms. Bihani submits that she may be allowed to take step upon respondent number 5 and 6.
Yes, my Lordship.
5 and 6, pair allowed, step be taken by speed post and also by usual process within a week from today, list after 4 weeks.
Much honor.
23.
None appears for the applicant on call, list the matter after 1 week. In the event of subsequent non-representation of the applicant, appropriate order shall follow.
24.
May I please, your Lordship? Lordship, regarding service and record case is ready for hearing, my lord.
Service completed.
Yes, my lord.
Heard Ms. L. Sharma, learned counsel for the appellant. Ms.
P. Barua, Lordship.
D. Barua, learned counsel for the respondent number 1. It is submitted at the bar that service in this matter has been completed and the LCR has been received.
Yes, my lord.
Then as such, the matter may be listed for admission, no, for hearing.
Hearing. My name is.
Accordingly, it is provided that receiver shall list the matter for hearing in usual course.
Obliged, my lord.
Item numbers 26 and 27.
May please allowed. Lordship, in this case, Lordship, just chairman of the hyper committee, that
Hmm.
is respondent number 4.
Hmm.
till date, Lordship, no affidavit has been filed. Yes, Chairman of the High Court Committee, Lordship.
Who is the chairman?
Lordship, there is respondent number 4, Lordship.
Respondent number 4.
In the last.
Whether he is going to file any affidavit?
I'm not representing him, Milord. I'm representing the respondent number 1 and 3.
1 and 3.
1 and 3. 1 and 3 has already filed their affidavit. And respondent number 5 has also filed the affidavit. And respondent number 5 is represented by Mr. P. Gogomila, some like this, some other. Chairman, would I represent?
P. Sharma. P. Sharma is represented. In last locations, Lordship, P. Sharma was absent.
B. Sharma.
P. Sharma.
P. Sharma.
He's so position. In last locations, Lordship, P. Sharma also absent.
We are appealing for respondent number 5 on behalf of. For respondent number 5, we have filed an affidavit, Lordship. We have been just informed by the registry that one or two pages, there's some translation issues, not translation, but effective, Lordship. But otherwise, we have filed our affidavit.
Lordship, corrected. I have received this copy.
Yes. The only issue is, Lordship, on behalf of respondent number 5, Lordship, we have filed our affidavit.
Who is for respondent number 4 then?
Respondent number 4.
P. Sharma.
P. Sharma, name is reflected.
P. Sharma.
Yes.
P. Sharma.
P. N. Sharma.
No, just P. Just P. Sharma.
I think you would be some government council.
Record of number.
Chief Secretary. Government.
P. Sharma's Kalatama is there.
Sharma. P. Sharma. Okay, after some time, he will contact the council.
Lordship. Highly obliged.
My pleasure. My lord, already in this case, service is complete on the respondents, my lord.
All the respondents.
Yes.
Okay.
And
1 and 2.
1 and 2. Madam Po?
I am for 3, I suppose. No, I'm for 1.
he is 2, 3.
1, 2, 3. Sorry.
Lordship, but
And
the
service-
appeal, Lordship, certain annexes are given, those are not provided to us along with the. Only the.
Mr. Secretary provided.
Yes, yes. Keep one.
Heard. Mr. Secretary, learned counsel for the appellant. Ms. Mozumdar for the respondent number 1. Mr. R. Borua for the respondent number 2 and 3. It is submitted at the bar that service in this matter is completed and LCR has been received. And as such, the matter may be listed for hearing. Accordingly, it is provided that the SSL lists the matter for hearing. In usual course, Ms. Mozumdar submits that she has not been furnished with some of the annexers of the memo of appeal.
That will be provided.
All the
Today.
annexers. Mr. Secretary undertakes to furnish the said annexers to Ms. Mozumdar within a period of 1 week from today. List after.
My lord,
list
the record has been called. So the
report has been received.
It was earlier, there was no record.
Whether it was called for,
No, it was not called for any record. I feel so.
not called for.
Record may be called for.
Later on, it appears that the record has not yet been called for. Accordingly, it is provided that SSL urgently requisition the record of MSC case number 642 of 2019 from the court of from the member MSCT Kamrup M Gauhati. Number 1 or number 2? Number 2.
Number 2.
Number 2, Gauhati. List after Then 2 weeks,
Yes.
after 2 weeks.
Yes.
Item 29.
Obliged.
May I please your lordship?
Yes,
As per business dated 1/6/2026, ID card as well as service report of respondent number 3 and 4 are awaited.
3 and 4.
3 and 4. Respondent number 1, 2 and 5 already appeared.
Lordship, I am appearing for respondent number 5.
5. One and 2 service completed.
Yes, sir. They are already appeared.
Appeared.
They are local.
Okay, heard Ms. Sarma for the appellant, Ms. Liani for the respondent number 5. Office note dated 1/6/2026 indicates that service report in respect of respondent number 3 and 4 are awaited. And LCR is also awaited. List the matter after 2 weeks, awaiting service report upon respondent number 3 and 4. Then shall issue urgent reminder to the learned tribunal for transmitting the record. List the matter after 2 weeks.
Item 30.
May it please your lordship. Lordship, by the order dated 27/5/26, last opportunity was given to the respondent lordship to file their objection lordship in IA lordship, IA for condonation of delay. As they have not filed yet lordship, delay may be condoned lordship. Delay petition is pending since 2025 lordship.
Your Lordship, I am appearing on behalf of Mrs. R. Devi. She is on next, kindly take up the matter.
R.
R. Devi.
Deb.
Devi.
JB.
Kindly take up the matter after the some time.
Okay, after some time.
Office.
31.
Same. Okay.
32.
May it please your lordship. Your lordship, this is an IA for delay of condonation, your lordship.
Hmm. You have taken a step?
Yes, your lordship, we have taken the steps. I'm a 31-year-old widow, your lordship. I have a minor 6-year-old daughter. And I applied the certified copy after expiring of the limited period, your lordship. And my financial condition is not well and my health is also not well. That's why I live in Tinsukia. And to communicate with the council and to get the guidance, it took time, your lordship.
Heard Miss?
B. Soren.
Learned counsel for the applicant. None appears for the respondent number 1, though one advocate has filed Wakalotnama. Office note dated 2/6/2026 indicates that ID card in respect of respondent number 2 and 3 has been received by the section with illegible signature. And neither edit card nor unserved notice in respect of respondent number 4 has been received. You take fresh step upon respondent number 2, 3, and 4. So edit card though received back by the section, there is one signature, but it is not legible. The learned counsel for the applicant is directed to take fresh step upon respondent number 2, 3, and 4 by speed post and also by usual process within a week from today, unless the matter after 4 weeks.
Item 33.
My lord, service is complete upon respondent number 1 to 5, my lord. And 6 and 7 awaited, my lord.
6 and 7.
Appeared.
The
Service is complete, my lord. Then
You are appearing for
I'm for claimant 1 to 5.
reminder,
1 to 5.
1 to 5.
reminder should go for as TCR, my lord.
Who appeared for 6 and 7? D. Gogoi. Okay. Third, Miss L. Sharma, learned counsel for the appellant. Mr. Your name, please?
G. Bokulia.
Z. Bokulia, learned counsel for the respondent number 1 to 5. None appears for the respondent number 6 and 7, though one Mr. D. Gogoi entered appearance earlier. This IA is for condonation of delay.
No, my lord.
Stay.
One for stay, 1 for they want to reduce additional evidence.
Mr. Gogoi is present? Okay. No.
D. Bokulia.
Yes.
I can call him.
Okay, call him.
Apart from that.
Yes. Problem.
Item 34.
May please your lordship. Lordship on the office note dated 3/6/26 has been received. Lordship records have been received. Lordship may fix the matter for hearing.
Service completed or not?
Lordship,
Service
service have been done
awaited.
of copies, right?
Okay. Record. This is Heart Miss,
You be honey.
learned counsel for the appellant. It appears from the order dated 4/5/2026 that though the matter has been admitted Notice has not yet been issued to the opposite party. Whether any counsel appeared on that day?
My lord.
My lord's notice have been served and records have been called, the records have been received. My lords may kindly fix the matter for hearing.
But it appears that one Miss Das Miss M Das entered appearance for the respondent. And office note dated 3/6/2026 indicates that LCR has been received. And since service is completed and the LCR has been received, receives a list the matter for hearing in usual course. Next.
33. Family 33.
This IA is for staying operational.
Let's go to step, at this stage, I will not press lordship. One is for the addition additional evidence lordship. Notice was issued, already I have taken step lordship. Because the policy was not exhibited before the trial court. Insurance policy was not exhibited before the trial court. That is why I filed a petition for under order 41 rule 27.
No, why should we keep this IA pending?
Lordship.
Why should we keep this IA pending?
No, this will be considered at the time of the hearing, lordship. I for the addition.
No, is there any rule of that this IA should be heard at the time of hearing?
This is the practice of the court, lordship.
Practice. Is it provided in the High Court rules?
I number 4106/2025, lordship. 4106.
If you were not going to press this IA, we will dismiss it.
Not for the dismissal. I shall place this.
Pardon?
I will place this, lordship.
When?
Today also, lordship.
Yes, all the parties are before the court.
Lordship. Lordship, this is Madhav Suike was engaged as a helper for the vehicle, lordship. And insurance policy of the said vehicle was issued by the petitioner company, lordship. And there was no coverage for the employee other than driver of the vehicle. Lordship, I have produced the policy, lordship, along with my IA, lordship.
Why it could not be produced before the tribunal?
Lordship, it is a lapse on the part of the lordship.
Lapse.
Lapse on the part of the.
You see the provision 4127, order 41 rule 27.
So lordship, today I am not prepared. It may come next week, lordship. I shall satisfy, lordship.
My lord, submit, my lord. The counter is by the appellant is not right, my lord. It's actually not correct, my lord. Policy was exhibited, my lord. I have the original record, certified copy of record. they have given cross the owner on that point. The evidence is also with me, madam. And the owner has duly exhibited the policy.
Hmm.
Six months, it is certified copy.
Then where is the question of
Owner produced the policy, but we did not.
It is the
produce
same
We
policy.
have put question, there is only the list on it, madam.
Okay, you are not prepared. Okay, today you are not
Lordship.
prepared. Heard Mr. K.K. Bhatt, Learned Counsel for the applicant. Mr. Bokolia for the respondent
One.
number
Respondent 1 to 5.
1 to 5. Respondent opposite party number 1 to 5. Mr. Gogoi for respondent number 6 and 7. This interlocutory application under Order 41, Rule 27 of the Code of Civil Procedures prepared by the appellant to adduce additional evidence and document in the appeal. Let a copy of this interlocutory application be furnished to the opposite parties, and recess shall list this IA on Wednesday, next Wednesday.
So there is another for state.
Yes, what is your contention in the other IA
On that day, Lordship, I will place them.
on that day? Mr. Bhatto submits that IA number 4105 of 2025 may be considered on next Wednesday, along with the IA number 4106 of 2025.
Mid-page, your lordship.
Here a lot.
I am extremely sorry, lordship, with respect to item number 20, lordship, I have missed the lordship.
I am not taking 28 now. Take a date from him.
35.
May please your lordship. Lordship, similar order may be passed in item number 35 and 36.
Item number?
Lordship, the order that was passed in 34, similar order may be passed in item number 35 and 36.
Yes, heard Ms. Bihani, Learned Counsel for the appellant. You are for the?
On behalf of S. Kakoti.
You Borthakur, Learned Counsel appearing on behalf of Mr. S. Kakote, Learned Counsel for the respondent. Office note dated 3/6/2026 indicates that LCR has been received. And since service in this matter has already been completed, this shall list the matter for hearing in usual course.
36.
My lords, similar order in 36 also.
Heard Ms. Bihani, Learned Counsel for the appellant. None appears for the respondent on court. Office note dated 3/6/2026 indicates that LCR has been received. Recess shall issue recess shall list the matter for hearing in usual course.
Item 37.
My lords, records have not been received yet. My lords may kindly call for the records.
Heard Ms. Bihani, Learned Counsel for the appellant. None appears for the respondent on court. Office note dated 3/6/2026 indicates that LCR has not been received. This is also urgent reminder to the learned. Railway Claims Tribunal, RCT, Gauhati, to transmit the record of OA Roman 1-03 of 2014 without further delay. List after 2 weeks.
Much obvious.
Item 39.
My lord, service is complete on respondent number 1 and service may be awaited on respondent 2 and 3, my lord.
Third, Ms. L. Sharma, learned counsel for the appellant. Office note dated 3/6/2026 indicates that service in respect of respondent number 1 completed. And when counsel entered appearance by filing Ukalatnama, but neither unserved notice nor AD card in respect of respondent number 2 and 3 has been received by the section till date. List the matter after 2 weeks awaiting service report upon respondent number 2 and 3. The registrar also put up an up-to-date office note by tracking the consignment in the departmental website. List after 2 weeks.
Obvious will.
Item 40.
May I please your lordship? Lordship, we withdraw this petition. Withdraw this petition, lordship.
This is a delay condonation petition.
Delay condonation in substitute petition. After the judgment passing and after the death of the claimant, we file this substitute petition with delay petition in High Court, lordship. We go for execution, lordship, in tribunal.
Yes, Mr. Bhatta, any objection? No objection. Third, Mr.
A.U. Ahmed, lordship.
A.U. Ahmed, learned counsel for the applicant, and also heard Mr. K.K. Bhatt, learned counsel for the respondent. This interlocutory application under Section 5 of the Limitation Act is preferred for condonation of delay of 859 days in filing substitution petition. In respect of substitution of legal heirs of respondent number 1, let Sahidur Rahman. Where is the application and the documents plus on record? The learned counsel for the applicant submits that Sahidur Rahman suffered demise on whose date he died?
Lordship. (11/1, 2023), lordship.
11/1,
2023.
2023. Then why the application could not be filed in time?
Lordship, we send a letter to the registry, and after that, High Court's order that we file the application, proper applications before this court, lordship. Then we file the substituting petition in this court, lordship.
That after the order being passed by a coordinate bench of this court on 28/8/2024, an application was filed before the registry for substitution, and in the process there was delay of 859 days in filing the application, and the delay is not intentional and rather it is circumstantial, and therefore it is contended to condone the same. Mr. K.K. Bhatt, learned counsel for the respondent, opposite party submits that he has no objection in the event of allowing this application. Accordingly, taking note of the submission of learned counsel for both the parties, and also considering the explanations so put forwarded for the delay, this court is of the considered opinion that the delay is sufficiently explained, and accordingly the same is thence condemned. In terms of above, this IA instance disposal. In IA number 471. Heard Mr. So learned counsel for the applicant, Mr. K. Bhatt, learned counsel for the respondent. This application under order 22 rule 4 of the Rule 4, read with section 151 of the Code of Civil Procedure is preferred by the applicant for substitution of legal heirs and representative of deceased respondent number 1. That is left Sohidur Rahman. In view of the order dated 28/4/2024 passed by a coordinate bench of this court in MSc Appeal number 33 of 2015. The learned counsel for the applicant submits that respondent number 1, Sohidur Rahman, suffered demise on. I got that to question again. On 11/1/2023. And as such, there is a requirement of substitution of his legal heirs in MSc Appeal number 33 of 2015. Mr. Bhatt, learned counsel for the respondent opposite party submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this interlocutory application stands allowed. The legal heirs of deceased respondent number 1 be substituted in MSc Appeal number 33 of 2015. In terms of above this IA instance disposal, in view of the order passed in the IA number 471 of 2026, the learned counsel for the appellant shall file amended cause title in MSc Appeal number so and so within a period of 1 week from today. One more IA is pending.
Abatement petition, Lordship. 472 of 2025.
IA number 472. Heard Mr. So-and-so, learned counsel for the applicant, and Mr. K. Bhatt, learned counsel for the respondent. This application under order 22(9) of the Code of Civil Procedure is preferred by the applicant for setting aside abatement of appeal in respect of respondent number 1, namely, let Sohidur Rahman, who suffered demise on 11/1/2023. The learned counsel for the applicant submits that the applicant submits that respondent number 1, let Sohidur Rahman suffered demise on 11/1/2023, and on account of his death, the appeal against him stands abated, and the legal heirs of the respondent number 1 has already been substituted in the MSc Appeal, and as such, there is a requirement for setting aside the abatement of appeal against the respondent number 1. Mr. Bhatt submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties and also the facts and circumstances on the record, the abatement of appeal against deceased respondent number 1 stands set aside. This IA is disposal. Within 1 week, you have to file substitution petition in this amended cause title in MSc Appeal number 33.
26 and 27. Okay.
Yeah, sorry, I had a medical issue, Lordship. I went to H. I had a stroke in October. And coma.
Okay.
Was it coma also?
Okay.
It's almost it.
Okay.
But in this case, okay, maybe I got the instruction, so I will file that very quickly.
When?
Leave me 2 weeks time, Lordship.
2 weeks
I
time.
got it.
Okay.
Lordship, wait, 1 week up.
2 weeks, the other.
Lordship, my petitioner already supernations
Pardon?
petitioner. Yeah, he already got supernation age. So that's why Lordship, after 28 years later, he is still no
15 days,
pension.
nothing will
Nothing.
happen, Lordship.
If possible, 1 week, Lordship, my parent already, I think, ready to file. Quick, 1 week, apni kole mo.
Okay. Heard Mr. Hawk, learned counsel for the petitioner. Mr. Sharma for the respondent number 5.
Yes, Lord.
5.
Four.
Respondent number 4. Mr. Soliha for respondent number 5. Mr. Kosik for respondent number 1 and 3. 1, 2 and 3. 1, 2 and 3. Mr. Sharma, learned counsel for the respondent number 4, submits that he may be granted some time to file affidavit. They are allowed to list the matter on COVID.
22nd June. After vacation also.
It should be after vacation only because from 15 onward, this court will not be sitting here.
Lordship, then one Lordship, then no further time will be granted. That observation will be given, Lordship.
You file it.
Lordship. Highly appreciate.
Item 41.
My lord, this IA is for the condonation of delay of 140 days, my lord. Here, my lord, one thing, my lord, what the grounds I have taken for the condonation of delay, my lord, this is suspicious, my lord. And my lord, what happened, my lord? I am coming to the review, coming to the court by the review application. Is that, my lord, lordship passed an order on 11/9/2025. And by this order, my lord, my PR was not granted and rejected, my lord, accordingly. And thereafter, what happened, my lord, the petitioner filed an application under the Right to Information Act and seeking information whether the post of the is a lecturer in civil engineering department is laying vacant or not. As per the response, they answered that the one post is laying vacant in the civil engineering department in the one post is laying vacant in the government polytechnics in Assam, my lord.
So, Mr.
But
Borua,
now the-
first we have to condone the delay. Any objection? No objection.
I don't have any objection.
Heard Mr. Borua, learned counsel for the applicant, and Mr. Das for the respondent, opposite party. This application under section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 140 days in preferring review petition. For reviewing the order dated 1/4/2026.
Review the order dated, my lord, order the 11/9/2025.
What you have mentioned in the
My lord, this is,
title.
now this is the another order, my lord. This is the another order. This is for another order, my lord. I am my review application for against the order dated 11/9/2025. My lord, I have prepared the review petition in the light of this order, my lord. In this order, that order has been passed in WPC number 2651. At page 4, para 2, my lord.
No, to review which order you have filed the application.
In the review application, can you peruse the review application?
for title was written because he has filed one petition. Then liberty was given to approach.
Your lordship, and that order, Honorable Justice Nelson Silo order, as per that order, my lord, I have preferred this review application. In prepared this review application, my lord, there is a 140 days delay was occurred. Other hand, my lord, my case is for that against that order, my lord, 11/9/2025.
No.
It's a bit confusing, madam, yeah, because
It is confusing.
bit confusing.
It is confusing. Which order is to be reviewed? You have
Review,
to
my lord,
mention
that is
here.
the page 30, my in review application from this. Page 30, annexure 8, my lord.
In the cost title, nowhere you have mentioned the about that order. For reviewing the order dated.
Mentioning page 4, madam, there are two of the
Yes.
delay on the application.
Yes.
To order review for application.
There are two.
Pardon?
Two, page 4 of the IA.
For review of the order dated 11/9/2025 passed in WBC number 2651 of 2025. Mr. Borua, learned counsel for the applicant submits that, where you have explained.
I have explained in the paragraph 8, my lord, that the applicant review petition more respectful, page 8, paragraph 8. Submit that the delay in preparing the application for the condonation is not intentional and deliberate, since the liberty to file the appropriate petition was granted on 23/2/2026 and the present review petition was filed on 2/3/2023. The delay occurred if counted from the date of order dated 11/9/2025, but at the time of the review petitioner was unaware of the fact that one post of the lecture in civil engineering department in government polytechnics of
Learned
Assam, and
counsel for
after
the applicant submits that liberty to approach this court for filing review petition was granted on 23rd/2/2026. And the review petition was filed on 2/3/2026. And the delay occurred, if any, has to be counted from the order dated 11/9/2025. And at that time, the petitioner was not aware of the fact that one post of lecturer in civil engineering department in Government Polytechnic of Assam is lying vacant. Lying vacant. And that the delay is not intentional, rather it is circumstantial, and under such circumstances, he is contented to condone the same. Mr. Das, learned counsel for the respondent opposite party submits that he has no objection. We are taking note of the submission of learned counsel for both the parties, and also having found the explanation so put forwarded in paragraph number 8 of the application satisfactory, this court is inclined to condone the delay of 140 days in preparing the review petition. In terms of this IA disclosure. In view of the order passed in the IA, now the registration registered the review petition and list the same before the court on Wednesday, next Wednesday.
not Wednesday 10th. Any other day, my lord, not on 10th.
Pardon?
Any other day, not on 10th, my lord.
Sorry. Tuesday then.
Yes. Oblige, your lord.
42.
May I please your lordship? Lordship, for condemning the delay of 57 days, lordship. Notice making short, lordship.
57 days.
Lordship.
Heard, Miss
J. Akhtar.
J. Akhtar, learned counsel for the applicant. This application under proviso to section 173 1 of the Motor Vehicle Act, read with section 5 of the Limitation Act, is preferred by the applicant for condonation of delay of 57 days in preparing connected MSC appeal against the judgment and award dated 22nd of December 2025, passed in MSC case number 159 of 2024 by the learned member, Motor Accident Claim Tribunal, Bangladesh. Issue notice to the respondents, returnable in 4 weeks. Sole respondent. Is to be taken by speed post and also by usual process within a week from today, list after 4 weeks.
Item 43.
Your Lordship. Lordship, this present I is for release of the deposited amount, Your Lordship.
Lordship, I have a prayer. I'm waiting for one time to file objection, my lord, in this case, in this IMN.
You want to file objection?
Yes, my lord.
Why?
But the ground is, my lord, regarding the non-involvement of the insured vehicle, my lord,
Non-involvement
of the vehicle, my lord. Till I will file one objection, my lord, that will be on the record, my lord. 1 week time, my lord. Only 1 week time.
Heard Mr. A.N. Iqbal,
Yes, Your Lordship.
learned counsel for the applicant. Mr. D. Kolita for the respondent opposite party. This application is preferred by the applicant for allowing him to withdraw 50% of the awarded amount deposited before the registry of this court by the respondent. Mr. Kolita, learned counsel for the opposite party, submits that he may be granted 1 week time to file objection. Pair allowed, list the matter on next Kobe
15th, Your Lordship. 15th.
15.
15/6. 15/6. 15/6. Oblige, Your Lordship.
Item 46.
It's a matrimonial appeal. We want to settle for mediation. This matter.
I am for the sole respondent for the wife, my lord.
It may be referred to mediation.
Mediation.
Okay. Heard Mr. Gogoi for the appellant. Mr. Mishra for the respondent.
Sole respondent.
Sole respondent. It is submitted at the bar that this matter may be referred to the Gauhati High Court Mediation Center. But in view of the submission of learned counsel for both the parties, it is provided that places shall list the matter before the mediator Gauhati High Court Mediation Center for mediation. Both the parties are directed to appear before the mediator on or before on or before 22nd of June 2026. After the mediation, the mediator shall file a report before this court.
47.
List immediately after receiving the report of the mediator.
Lordship matter may taken after some time, Lordship. My senior is in another kindly, but sometime.
Who will appear?
Yes, I'm.
You are for?
I'm for yes, I'm petitioner. 47, 48, same.
This I is for, I is for.
One week time, maybe accorded to the program, file objection. 602 days delay.
This is MSA appeal.
Has appealed preferred by the citizens. Subsequently, they have probably to take. And the advantage they are having, so we may be allowed to file application.
Heard, Mr.
T. Uddin.
T. Uddin, learned counsel appearing on behalf of Mr. S. Ahmed.
Yes, I'm.
Learned counsel for the applicant, and also heard Mr. Kolita, learned counsel for the opposite party. Mr. Kolita submits that he may be granted 1 week time to file objection. Where allowed, list the matter. Fix a date.
17 June.
17 June.
What is same? 28th.
Same.
Same. Apologies.
49.
Early hearing. Who filed this application? You?
I have filed.
Okay.
I have challenged the decree of divorce, Lordship. I am for the wife.
Divorce is already granted, Lordship.
Divorce was already granted. They have challenged the divorce order.
So early hearing, you suggested that then?
Yes, 16th of July, Lordship.
16th of July. Heard Ms. P. Bhattacharya, learned counsel for the applicant. Mr. A. Sharma for the respondent. This application is preferred by the applicant for early hearing of Met Appeal number 47 of 2024. Accordingly, it is provided that accordingly, after hearing learned counsel for both the parties, it is provided that recusal list the matter on 16th.
Yes, please.
16th of July. Okay.
Obliged.
I stand satisfied.
Item for admission. Item number 2. Alternate.
Also, on the last occasion, my learned trainer was not. Yes.
Who appeared? Didn't pay.
Submit courier.
So whether you have received a proposal from the inspector of school?
Not, Lordship.
The director has written the letter to the inspector on which date?
Yes, Lordship.
When? Why you have not received the same till date? After sending the letter, what action you have taken?
It's yet to come from the inspector of school, your lordship.
Here inspector of school is also a party?
No, Lordship.
No.
Also, as per my information, inspector of schools has forwarded it long way, Lordship.
When?
Lordship, I will have to obtain that instruction. Lordship, may I place one document, Lordship, in respect of other principals, Lordship, they are doing it in normal process. Only the, Lordship, they are taking. I have to come for each and everything, Lordship, for in before this honorable court, Lordship. And I retired, for last 1.5 years, Lordship, I worked as a regular principal. They did not give me the scale of principal, Lordship. I received the post, salary in my substantive post as PGT English, Lordship. I joined service, Lordship, as regular principal, Lordship, on 19/9/2024. And retired on, Lordship, 31/1/2026.
No, Mr. Das,
That's it.
when the inspector of school
That's it.
has furnished the requisite information to the director, this search taking report, have you gone through the letter
Yes,
he has
that's my
produced
case.
today?
Taking report, Lordship, on the earlier occasion, Lordship, it has already been submitted. There was a confusion, Lordship, because the principal was also holding the, who will, Lordship, since she was holding the in-charge principal also. So she has given the charge to the inspector of schools. That has been clarified, Lordship. On, Lordship, previously, Lordship, by several orders, Lordship, may kindly see the last few orders, Lordship. It has been clarified, Lordship. That is long back, Lordship. It is only with regard to pay protection laws.
Now, in this second paragraph, you see
Lordship.
the government by communication dated 8th of May 2026 again instructed the directorate to furnish the proposal along with search taking report.
Lordship. That is in January.
No, not January. May, 8th of May.
Yes. Again, instructions. Lordship.
And thereafter, the inspector of school, CDC Kasar, was requested to provide the above mentioned document
Lordship.
to the directorate.
Lordship, may I take instruction from the Lordship, my client, Lordship, because she has some communication.
Instructions she has to obtain from the inspector.
Lordship, she can also obtain, Lordship. Because it is their same department. Lordship.
Heard Mr. S.K. Das, learned counsel for the petitioner, Ms. Terampi for the respondent. Authorities. Pursuant to the order dated 1st of June 2026, Ms. Terampi has produced one letter of the director, secondary education, dated 4th of June 2026. And perusal of the same indicates that as per office letter number E dash 581/514/124, the inspector of school CDC Silsor was requested to provide proposal, to furnish proposal along with search taking report. Ms. Terampi submits that the requisite information has not yet been received.
Yes, Your Lordship.
Not yet been received. Mr. Das, learned counsel for the petitioner, submits that he may be granted some time to obtain instruction. from the inspector of school. Where allowed, Ms. Tarangpi is also directed to obtain instruction from the inspector of school CDC Silsor as to whether person to the letter dated e-letter number the requisite information has been provided or not. Recessal is the matter on 10th of June.
No, so if they can specify what are the required documents, because inspector of schools sends the proposal, they again raise the objection, lordship.
No, they start taking report. It is
Starts
mentioned
taking
in the letter.
Okay.
The letter
Obvious.
published before the court today by Ms. Tarangpi shall be marked as annexure A and be tagged with the record. So Soma, the other side is absent.
But it was the matter on the second day matter. Earlier occasion also they are absent matter. This honorable court is asked a very particular order.
None appears for the appellant on call. However, Mr. Sharma, learned counsel for the respondent present. Mr. Sharma has pointed it out that on 25/5/2026 also, the appellant remain absent. Further, it appears that on 6/4/2026, 31st of May 2024, of 15/5/2020. Also, the appellant remained unrepresented. In view of above, this RFA stands dismissed for non-prosecution. Recessal return send down the file of the record of the learned court below for tweet.
Declare.
No, this is an appeal against the injunction order, my lord. My lord, I'll place on from the text, my lord, that the petitioners were running, my lord, school and colleges, my lord, high school, junior college, and etc., my lord. They were from custody of fund, my lord. The plaintiff respondent, my lord, said that you will finance it. They obtain a MOU, but that was also, my lord, fraudulently obtained. That your loss will find at page 123, my lord, of the memo. I shall go to that first one before going to it. My lord, this is a property of the trust, my lord. Managing director is not authorized, my lord, without the trust board. But it is a MOU between managing director, trust is not a party, and the plaintiff respondent. My lord, next page, your lord will see. Your lordship got the trust deed, my lord. Trust deed, your lordship got. Hey, MOU. Yes. Second page, my lord. Whereas the first party, one is the managing trustee of the Learners Education Trust, non-government education trust, having Learners High School, Learners Junior College with residential boarding situated at Santinagar, non-government, so-and-so, at Tinsukia, which are standing over a plot of land measuring 8 bighas covered by so-and-so, situated so-and-so. Whereas first party, number 2, by registered power of attorney, so-and-so office of the senior sub-registrar Tinsukia has authorized empowered the first party number 1 to do and execute, perform all the acts, deeds, things for her and on behalf of the so-and-so. Whereas second party is the doctor in political science, so and so, so and so. Now, next. Whereas the aforesaid school is run and managed by the first party having registration number so and so. Whereas the first party number 1 maintain bank account number so and so being operated as principal, another bank account number so and so standing in the name of the juniors, Lana Junior College being operated by him together with Jiraj Sharma, personal assistant of the first party number 1, both so and so. Now, whereas the first party having serious financial problem in running the said education institution and has incurred heavy financial liabilities, which has necessitated and required to be settled with intending creditor after assessing the proper account maintained in the regular course of and duly audited. Now, this is important, my lord. Where the first party have offered the second party with a proposal to run the educational institution to overcome with the financial crisis, and second party has come forward to provide financial assistance to first party. They wanted to give financial assistance and agreed and decided to run the educational institution in furtherance thereof. Both parties have decided to enter into a mutual understanding. Whereas the second party has agreed to invest a sum of rupees 1 crore. My lord, the property valued more than 20 crore, my lord. They run the educational institution henceforth to and from the date of execution of this indenture on the terms and conditions appearing herein below. In pursuant to aforesaid negotiation, in consideration of a sum of rupees 1 crore to be invested by the second party against the discharge of liability of first party, the first party has handed over the total management of the said educational institutions along with existing infrastructure, including land and other mobile properties, in favor of the second party with all its existing facility, including the rights, operation of bank account, delivery of the taking over so and so, institution so and so. Accordingly, informed all concerned authorities of the said educational institution, district, and concerned bank for the purpose of so and so. So, my lord, you'll also find, my lord, that by this MOU, fraudulently it is obtained, but we have filed a separate suit also. But even then, he has obtained to invest 1 crore rupees and taken over the running of the school. This is not a lease, neither agreement for sale. This is a fiduciary relationship, my lord. He is running the school on my behalf. Now, in such case, my lord, can he get a suit filed and declare that he is entitled to run the school, my lord? First thing, my lord. This is not there is no point case. We have said that proper accounts of the liability of first party so and so, everything, my lord, we have said in that. So, my humble submission, my lord, that first thing, that this is a fiduciary relationship. This is not neither a lease nor a agreement for sale. Now, if your lawsuit see, in the suit, my lord, we see that page 51, you know, written. And the prayer portion, if your lord will find, my lord, that is 61.
Page number
61. For declaration, the plaintiff have acquired valid and enforceable rights having legal authority over in respect of the suit property under the memorandum of understanding. He cannot get it entirely, my lord. He is running the school, he is appropriating the income of the same. For last 7.5 years, he is running the school. My lord, investing, my lord, 1 crore, my lord, he is running all the schools, colleges. They have mentioned 2, my lord, there is another school. Similarly, my lord, declaration, my lord, that he is entitled to continue the control and management of suit property. How we can, my lord? These theirs are not at all, my lord, maintainable, my lord, at all. Oh, my lord, your losses, Right, my lord, I think.
Okay, after five.
My lord. Deed also, we have a next, my lord, you just may see, page 109. We have a next task deed also. My lord, and there is a board of trustees, my lord, at your lordship find, my lord. At page 114, board of trustees are there. So they have to take a decision in the board of trustees. There is no resolution in the board of trustees. To, no. One and for board of trustees are there. And managing director's power is absolutely very small, matter that at 117 plus 20, managing director's power. I'm sorry. My lord, managing director's responsibility are there. Actually. My lord, at page 115, clause 11, duties of the managing director are mentioned. Nowhere he has been authorized, my lord, in this manner to give the property on somebody else. For this reason, my lord, trust has also filed a cross suit. And we have brought the cross suit by filing an affidavit. Your lordship will find that affidavit, my lord, which is at, starts at page 129. And prayer portion on the length, my lord, length starts at 132 and prayer portion is at 159.
Okay.
Because although in the MOU, 8 bighas is mentioned and only two, one college and one here, but there are other schools and colleges and other properties are there. Everything has been taken over by him.
Page number 100 and
My lord?
page number.
Page number 129.
Of trial court record.
No, my lord, affidavit. Affidavit by the additional affidavit. Additional affidavit filed by us on 8/1/26.
You see, the last page of this appeal
FA or not, my lord? FA
is 127.
Yes.
Yes.
Additional affidavit.
That starts from 129, my lord. That
Last page, 128.
128, my lord, last page, that thereafter, my lord.
Starts from
129. Anyway, I shall come to later on, my lord, because that will make it clear, my lord, that the managing director is not authorized, my lord, to do it. And moreover, there is 14 bighas of land, my lord, and other properties are also there. He has taken over entire thing and sorry. Yeah, I can give a copy of the same, my lord. That may come. My lord. Only the plain, my lord, that. Did one I could read this.
Prayer portion.
When did you file the additional affidavit?
Well, 8/1/26.
It is not available on the record. It is not shown in the computer also.
No, we have supplied a copy, my lord. And we file it.
No, you file it, but it is not available in the system.
Okay. I do not know, my lord, where it has been kept. Anyway, just, my lord, your lordship, just see it, my lord, the prayer portion.
Prayer nikal ke.
Yes.
The suit property described in schedule so and so, and that defendant number one had no right to take over possession of the suit property, which is a trust property basing so and so. Then plaintiff number two, my lord, that he no authority to so and so. Now everything is there. Now your losses may come to next schedule, my lord. Schedule. A plot of land measuring 14 bighas. Dark number so and so, so and so, so and so. Then number one, learners preparatory nursing school, which is house in ground floor, first floor, so and so, so and so. Then learners high school. This is there, my lord. Then learners junior college, established in so and so. Then learners senior and junior boys hostel and wardens college. The learners girls hostel and wardens cottage. Learners kids hostel and wardens cottage. Staff quarters in a row so and so, so and so. A residential house measuring so and so of the managing trustee, come principal of the above institution, separate kitchen, dining room, so and so. A canteen, a godown, separate office accommodation of the principal. Kids park, arrangement of about 5 number of security personnel, badminton court, etc. All these things are there next also. So the vehicles or everything, my lord, under his control now. Now, my lord, I actually come, my lord, that the interim order, my lord, which is at page 10, my lord, starts at page 10.
Yes?
Page 10. And the finding of prima facie case is, my lord, at page 26. I shall come to that. The petitioner claim reliefs on the basis of MOU and speech power attorney, which is cancelled, my lord. And from these two documents annexed so and so, the petitioner primacy, it appears that the petitioner has the right to run the management and all affairs of the suit property. How long, my lord? I'm putting a question to me, my lord. The OP, on the other hand, have objected the said MOU and speech power attorney are illegal as the same are executed by playing fraud with the OP number 2. The petitioner has stated that he has been running the educational institution and affairs of the suit property without evidence and interference from the OPs, have started creating nuisance by trespassing the suit property and obstructing construction of works going on inside the suit property for development of infrastructure, etc. The parties have several disputes resolved in a full-fledged trial. Hence, it is sufficient to hold that these are prima facie cases. Now, this is down. Now, my lord, your lordship will find to irreparable loss and injury. I'm just skipping over the presence of convenience, which is at page 30. As the petitioner has invested huge amount of money in improving the financial affairs and management of the educational institution of the suit property in discharging liabilities of the OP number 2, if the OP number 2 is not abstained from creating nuisance and other hindrance over the suit property, the petitioner is dispossessed illegally from all powers given to him on the basis of the MOU. The petitioner will suffer a loss. It appears that OP have been in financial crisis since a long, for which it appears that they have entered into several agreements with not only the petitioner but also with technology so and so for financial condition, and therefore no irreparable loss caused to the OP cannot be compensated in terms of money. You will see the finding. Further, with respect to OP number 1 is a trust property, whether OP number 2 has the authority to delegate to hand over the management of the suit property, so and so, etc., are matters to be decided in trial. Furthermore, if the suit property is not decided in favor of the petitioner, suit is not decided, the OP will receive back the property as a whole. In my considered opinion, the above scenario is fit case for granting injunction in favor of the petitioner. Hence, this principle is also decided in favor of the petitioner as positive, and that is why the injunction is made. Now, my lord, I shall, in this regard, I shall place a decision of the Supreme Court, my lord. No problem. No, I shall not more judgment.
So, what are
2012.
the, Mr. Sahayola?
Yes.
What are the grounds you have challenged the
Challenge,
impute
my lord.
order in
First
this
thing, my
appeal?
lord, I shall come, my lord. Your lordships may see more one page more, my lord. That first thing, this is a fiduciary relationship. He cannot file the suit, my lord, for declaration that he will continue. This is a fiduciary relationship, my lord. I shall come to that. Secondly, my lord, we have filed a petition before the trial court that your lordship will find at page 105, my lord. That may be seen. 105. This is very important, my lord.
Yes.
Today is fixed for grant of vacation of temporary injunction. The claim of the petitioner is based on the contents of persons of MOU. He has paid the investor rupees 1 crore to a defendant in this school, basing on the so and so. He claims that in view of such investment, he has right to accrue in favor of the management.
No, that's all right. Whether any order was passed?
Yes,
in-
yes.
What happened?
My lord, page
Rejected.
108. Page 108.
Petition was rejected.
No, my lord, that is very important, my lord. Last para, my lord, your lordship see. The learned counsel for a plaintiff also submitted the plaintiff proposed to settlement on payment of rupees 2 crore 45 lakhs. My lord, monetary relief, my lord, your lordship see how injunction can be granted. He has invested 1 crore and he is earning the profit, my lord, from the school and colleges for last 7.5 years. And still he wants 2 crore 45 lakhs. Is it a irreparable loss, my lord? My lord, in this regard, my lord, I shall place the decision of court, my lord. Let me show. Thank you. You can. My lord, and that special relief act, your lordship knows, my lord, that against that true owner, my lord, no injunction can be granted, my lord. Special relief act. Your lordship may just see, my lord, section 41 of the special relief act.
Yes.
An injunction cannot be granted when the plaintiff has no personal interest in the matter. J. Then H, my lord. This is important. When an equally effectuous relief can be certainly obtained by an order, usual mode of proceeding, except in case of breach of trust. Here, monetary relief, my lord. Then, my lord, your lordship may see section 38, my lord.
Yes.
Subsection 3. Where the defendant invests or threatens to invade the plaintiff's right to enjoy property, the court may grant a popular injunction in the following cases, namely, the defendant is a trustee of the property for the plaintiff, where there is no standard of ascertaining the actual damage caused or likely to be caused by the investment. My lord, here that this is fixed, my lord, where investment of such that compensation money would not be afford adequate relief. Here he is claiming compensation of rupees 2 crore 45 lakhs. Well, how injunction can be granted? I shall place, my lord, two judgments. One first, my lord, 2012 6 SCC 792.
No, you have not stated the grounds.
Well, first thing, my lord, this is a fiduciary relationship. He cannot, my lord, file the suit, my lord, against me, my lord, for continuing, my lord. First thing. And secondly, he's not the owner. He against the owner, my lord, no injunction can be granted.
Pardon?
Against the owner, true owner, no injunction can be granted, my lord. Because there is no lease or agreement to sell of the property. He has MOU 8 bighas of land with two institutions, but he has taken over 14 bigha and my lord. About 20 crore property he is taking over, my lord. And for last 7.5 years, my lord, he's continuing the management. He is earning the income of the school colleges, my lord, for last 7.5 years by investing 1 crore. And this is adequate relief is there, monetary relief is there, my lord. His investment is only money, my lord, which can be compensated in terms of money. So there is no question of irreparable loss, my lord. The second petition your lordship has seen, my lord, they have offered that they want to settle on payment of rupees 2 crore 45 lakhs.
No, that was subsequent to passing of the order.
Yes, my lord. Subsequent, that is why, my lord, the court
No,
could
at
have.
that time of passing, that proposal was not available before the
My
trial
lord,
court.
that was subsequently it could have been vacated, my lord. That is why we filed a petition. When court finds that, my lord, that it can be, my lord, and moreover, from the very, my lord, nature of the suit, your lordship find, my lord, that the MOU is that he will invest rupees 1 crore. His investment is 1 crore. His life, my lord, the main custom matter is that his money is involved only, nothing more than that. The land, the schools, colleges, all belongs to trust, my lord. My lord, if your lordship see the, my lord, the Supreme Court judgment, my lord, that on fiduciary relationship also it is there. Twelve 6 SCC 792. I shall place, my lord, 4 paragraphs only. 16, 17, my lord, your lordship is see first.
Yes.
The learned counsel for the appellant cited the decision of Indian Oil Corporation versus so-and-so, in which court has held that a contract in which is in the nature of determinable cannot be enforced by the court. This is MOU only, unregistered MOU. That is not a registered also. They also cited the decision of so-and-so, in which court held that by relying on the Jabajama Century division of so-and-so, that where totality of the obligations between the parties give rise to a fiduciary relationship, injunction would not be granted because performance of duties imposed on the party in the fiduciary relationship would not be enforced at the instance of the other party. The suit itself is not maintainable, virtual marriage. The learned counsel for the appellants further submitted that the agreement between Liberty Agency and Respondent number 1 was an agency agreement. It did not create any interest whatsoever in the suit scheduled property, and therefore Respondent number 1 was not entitled to any injunction restraining the owner of the suit scheduled property from dealing with the property in any manner with the third party. Now, the next 2 paragraphs, my lord, more answer. 29 and 30. Yes, the settled principle of law is that even when primacy case is in favor of plaintiff, the court will refuse temporary injunction if injury suffered by a plaintiff on account of refusal of temporary injunction was not irreparable. In Dalpat Kumar versus so-and-so, satisfaction in the prima facie case by itself is not sufficient to grant injunction. Court further has to satisfy non-interference by the court would result in irreparable injury to the party seeking relief, and there is no other remedy available to the party except one to grant injunction, and he needs protection from the consequences of apprehended injury or disposition. Irreparable injury, however, does not mean that there must no physical possibility of repairing the injury, but means only that injury must be material one, namely one that which cannot be adequately compensated by your damages. My lord, here he cannot get the my lord, injunction in any manner, my lord. This is a fiduciary relationship, my lord. He has no right over the property. Then, my lord, the Gauhati High Court judgment, my lord, para 10 your lordship. My lord, that is 1984 1 GR, page 447. A bare perusal of the reply to the notice that is so will show that plaintiff assess the damage if agreement is terminated, and the plaintiff themselves assess the damages as will be evident from the paragraph quoted above. The question of granting injunction does not arise because the law is settled that if the damage can be assessed in terms of money or it can be compensated, the question of granting injunction does not arise. In that view of the matter, also the injunction ought not to have been granted. Further, the suit itself was for permanent injunction, and in such a suit for temporary injunction must be granted in a cautious manner because granting temporary injunction relief in the suit being granted. That should not be done by the court. No doubt, in specific cases, temporary injunction may be granted. The procedure for granting injunction should be adopted as a general and normal course. My lord, did you see relationship, my lord? I shall just place, my lord, Black's law, maybe. My lord, the Black Law Dictionary, my lord, your lordship see, this is 5th edition. Now is the fiduciary. The time is derived from the so-and-so person holding the character of a trustee or a character analogous to the trustee in respect of a trust and confidence involved in it and scrupulous good faith and candor which is required. A person having a duty and created by undertaking act primarily for another benefit in a matter connected with such under. An adjective means the nature of trust having the characteristic of trust, analogous to a trust, relating to and founded upon a trust of confidence. A person or institution who manages money or property for another who must exercise a standard of care of such management activity imposed by law or contract, the executor so and so. A trustee, for example, who possesses fiduciary relationship with the beneficiary of the trust to follow the transference. The status of being fiduciary gives rise to a certain legal incident obligations, including prohibition against the investing money or property in the investment, which are speculative and other imprudent. So actually, my lord, even if my lord that MOU is seen, my lord, MOU they understand instrument. Even then, my lord, his duty was my lord, he is invested 1 crore rupees he as per the MOU, and he will left. My lord, it not that he eternity he will run the entire property, my lord, and he will earn the and after 7 years, my lord, he has said that he is entitled to rupees 2 crore 45 lakhs. I do not understand. He has not given any, my lord, as per the MOU also, he has to give entire accounts, my lord. Nothing has been given. The and owner, my lord, he is totally ousted, my lord. He cannot go and see also. And by injunction, my lord, we are totally ousted. We cannot go and see also. The property ought to be 20 crores, my lord, is having it.
Okay. Yes, Mr.
So my lord, my full submission, my lord, that I'm just saying. 1 minute. That thing.
The scope of this honorable court while exercising appellate jurisdiction against injunction order. It's well defined in the Wonders Limited case.
Volume.
Wonders case.
Volume.
Nothing has been argued so far as those power on which this honorable court may like to conduct.
Nothing has been
Argued,
regarding.
regarding the principle on which this honorable court would like to exercise the power for interfering with the injunction order that has been passed. Because this honorable court will be interfering with the discretionary power of a trial court.
But when the discretion is applied in a perverse manner, then
That's what I am saying. Nothing has been argued on those aspects.
no,
All
Mr.
has been argued.
Sayawala has argued that there was a fiduciary relationship between the parties.
Right.
And in that case, injunction cannot be granted.
Yes.
And apart from this, he has also pointed out that this irreparable loss, it cannot be found as it can be assessed and it can be compensated in terms of money.
Yes.
So these two requirements gone. Prima facie case is there. It is not sufficient to grant the injunction.
I pose the question to myself, who is posing this question? The person who signs the MOU.
Mm.
Person who signs the MOU on behalf of the this trust is posing this question.
Mm.
The written statement or the written objection filed by the person concerned, not the trust.
Mm.
Now here also, my lord, the trust is said to be an appellant.
Mm.
But the trust did not file any objection, written objection, nor even the written statement.
Mm.
And whether he has that authority, that question will be bouncing to himself.
Mm.
But you could can be this wonders paragraph 14, just to highlight the thing.
Mm.
The appeal before the legal sense were against the exercise of discretion by the single judge in such appeals. The appellate court will not interfere with the exercise of discretion of the court of first instance and substitute its own discretion, except where the discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court had ignored the subtle principle of law regulating grant of defeated or interlocutory injunction. An appeal against exercise of discretion is said to be an appeal on principle. Appellate court will not reassess the matters and seek to reach a conclusion different from the one reached by the court below, if the one reached by that court was reasonably possible on the material. The appellate court would normally not be justified in interfering with the exercise of discretionary discretion under appeal solely on the ground that if it had considered it better at the trial stage, it would have come to a contrary conclusion. If the discretion has been exercised by the trial court reasonably and in a judicial manner, the fact that the appellate court would have taken a different view may not justify interference with the trial court's exercise of jurisdiction. So this is the principle which a discretionary power that has been exercised by a trial court can be effectively. But so far as the order, it's a well-reasoned order, my lord, considered all the aspects whatever has been submitted. He is heard at length, all the documents have been perused. An order here also they have seen page 10, but not the 11th portion matter. Not the 11th portion. If you also comes to page 10. For further directly come to paragraph page 3. The order is on page 10. I have perused the document of both parties. And more particularly the MOU, document number 1 of the petitioner and the special power of attorney document number 2 of the executed by OP number 2. Page 22. I have perused the documents of both parties.
And more particularly, the MOU, document number 1 of the petitioner and the special power of attorney, document number 2 of the petitioner, executed by OP number 2 in favor of the petitioner. From plain reading of MOU, prima facie it appears that though the MOU, the OP number 2 has handed over the total management of the educational institution, along with all existing infrastructure, including land and other movable and immovable in favor of the petitioner, including to operate a bank account, etc. The OP number 2 has not denied the execution of MOU dated 19/12/2018, but has claimed that MOU was executed by plain fraud and is illegal and not executable in law. Similarly, from a plain reading of the special power of attorney dated 19/12/2018 executed by OP number 2 in favor of the petitioner prima facie, it appears that OP number 2 has authorized an extended full power to the petitioner to maintain and operate bank account in the name of Learners High School and Learners Junior College, and to make correspondence of the state educational institution. To all authorities, including higher authorities, and to represent on behalf of him before any authority. The OP number 2 has also empowered the petitioner to appoint any representative, etc., etc. This is his case. If you want to look into the objection, these are the objections what has been said, not the submission which are made now. Those submissions were never made. The written objection contains, this is the only objection, that MOU was obtained by fraud. That is the only thing, and this finding.
No,
is-
maybe.
Yes, but let me come further, page 26. The prima facie case.
Yes.
These three principles that have been the petitioner has claimed release on the basis of MOU and special power of attorney, and from these two documents annexed as documents number 1 and 2 of the petitioner prima facie, it appears that petitioner has the right to run the management and all affairs of the property. The OP on the other hand have objected that the said MOU and special power of attorney are illegal and same have been executed by playing fraud with the OP number 2. The petitioner has stated he has been running the educational institution and all affairs of the property without any hindrance and interference until the OPs have started creating nuisance by trespassing into the property and obstructing the construction work going on inside the property and for development of the infrastructure, etc. The parties have several issues to resolve in a full-fledged trial, and hence it is sufficient to hold that there is a prima facie case for granting injunction. And the point number 1 is decided in positive in favor of the petitioner. Balance of convenience. From the document number 6 of the petitioner, that is correspondence made by the plaintiff petitioner regarding management and control of school, document number 7, which is resolution register of proceeding of school conducted by school management committee. Document number 8, which is the report of an incident of 5/5/2019 signed by guardians and teachers alleging the OP number 2 and 3 along with their man of obstructing the school building gates and requesting the school to be run by the new management without interference by the OP number 2 or any person related to him. Document number 10, which is a letter of support given by the school in phase of new management. New management means whether that is me. New management committee document number 17, which is a copy of complaint letter filed by the school management committee and staff of learners high school to the deputy commissioner against OP number 3 and other causing obstruction and treat to teachers, students, staffs, etc. Document number 8 is a copy of order passed by additional district magistrate in case number so filed by OP number 3 against the petitioner, wherein the additional deputy commissioner has prohibited the OP number 3 from creating any nuisance and hurdles in the school functioning of the school, and also prohibited the OP number 1 from revoking and cancelling the special power of attorney. It appears that the school management started by the petitioner person to MOU was getting fame and popularity amongst many, and the learners and guardians were also supportive of new management run by the petitioner as managing director of learners education institution. It has been alleged that OP number 3 in connivance with others have been creating nuisance by trespassing into the school property and threatening the workers engaged in construction work in developing infrastructure of the school property, and by demanding commission from the school fund, and also by interfering in the day-to-day affairs of the educational institution, disturbing the staff, students, and teachers in general. The OPs also have been alleged fitting the petitioner of dispossessing him from by the repeated act of creating nuisance and hurdles in his good relations, the result of which another was also not the Dumduma police station. His OP have on the other hand denied all these allegations and have put forward a different story alleging the petitioner and his man are forcefully confining OP number 3 inside her residence situated inside the suit property from where she managed to flee by climbing a boundary wall and went to the police station for filing a complaint. All these allegations brought by both the parties can only be adjudicated in a full-fledged trial considering evidence adduced by both the parties. However, in respect of this case, the matter does not confine to the personal right of the parties, but is related to the future of the student of two educational institutions of Learners Education Trust. The dispute between both the parties can only be decided in a trial. However, from the allegation made against the OPs about creating nuisance inside the school premises with the help of OPs for welfare and students, teachers, and staff and for smooth functioning of the educational institution, it is important to prohibit any kind of such illegal activities inside the school premises. Inconvenience will be caused to the petitioner, that is the students, teachers, and the staff of the schools at large if such illegal activities are allowed to be continued without restraining the office or any man on behalf of the office. But no inconvenience will be caused to the office if they are restrained from entering into the suit property and creating nuisance. Other than this pleading, Lordship may skip this portion, may come to next paragraph. On the contrary, the petitioner has produced several documents in indicates that the OPs have created nuisance and hindrance inside the school premises. A joint complaint was also filed by the teachers and SMC to the Deputy Commissioner Tinsukia in this regard. Hence, prima facie, this court is of the opinion that the petitioner has succeeded in bringing balance of convenience in favor of the petitioner and the principle is decided in the positive. Irreparable loss or injury. As the petitioner has invested huge amount of money in improving the financial affairs and management of the educational institution of the suit property in discharging the liabilities of OP number 2. If the OPs are not restrained from creating nuisance and other hindrance over the suit property and the petitioner disposes illegally from all the powers given to him on the basis of MOU, the petitioner will suffer irreparable loss. It appears that OPs have been in financial crisis since long, for which purpose it appears that they have entered into several agreements with not only the petitioner but also with one so and so for improving their financial condition. Therefore, no irreparable loss will be caused to OPs that can be compensated in terms of money. Further, with respect to the OP number 1 is a trust property and where the OP number 2 has authority to delegate or hand over the management of the suit property to any other person on behalf of the trust, etc. are matters to be decided in a trial. Furthermore, if the suit is not decided, this not OPs will receive back the suit property as a whole. Hence, in my considered opinion, from the above discussion, it is with case for granting temporary injunction in favor of the petitioner, and hence this principle is also decided in favor of the petitioner and in the positive. In the result, this restraint order has been passed. Now, few things are not admitted position. Property belong to the trust. He is the managing director of the trust. On 19/12/18, a MOU, a rightly or wrongly, a legally or fraudulently, howsoever that has been admittedly executed. A special power of attorney has been given to the OP to run and operate the bank account also. On the same day, as per the MOU, I have paid the liquidated various loan amounts which was burdened for him on the very day. And then also started investing in the school, apart from taking other welfare measures. Now, within a short time, the school has started running, and then the reputation has started going. Now, whole things have started there from. Now he started disturbing my possession. Handing over is admitted. Running by me is admitted. So at this stage, if they are allowed to interfere, as have been alleged in the injunction petition that on 16/4/2019, they have tried to dispossess us. There are complaints by the students also, by the teachers and the guardians also, that the OP's man and persons tried to close the gate, obstruct them from coming. The entire court has considered even the interest of the student of the school. Now, whether MOU is only a fiduciary relationship or not, or it intention, because barely leveling of the document cannot be said to be. It may be an agreement also. Merely leveling by MOU, that does not give a say that it's a fiduciary relationship unless the full the trial is taken up, the issue has been decided in appropriate form. So that's what the court finding is. Now, so far the second and what was his argument before the court? Also, we kindly see the written objection. Page. Written objection on page 96. Nothing has been stated. What has been submitted now, madam?
No. This law points can be raised at any forum,
Yes.
at any point of time.
Yes, that I'll come, madam. Then before that, madam, one more matter has been pressed upon with regard to a petition, madam, dated 2/9, madam. So that is, madam, at page 104. This is filed by him, offering to compromise the things, and so that outside the court settlement or amicable settlement can be done. His petition. It's not my petition. Legitimately, the 104. The projection has been only one line of the order that plaintiff counsel is saying that under what circumstances plaintiff counsel has said that has been camouflaged totally, madam. 104, madam. This is filed by the OPs, the present appellant. Now, principal can you see page 105, paragraph 5. For shortening, I'm not repeating the whole detail. Paragraph 5. Whereas the defendant has now overcome the financial crisis, which is recorded at page 3, paragraph 2 of MOU as the main limited purpose of entering into the MOU by the parties, and whereas the petitioner made enough income out of the school earning during 3.5 years and is not entitled to any further compensation as per the terms of the MOU, whether in terms of principal, return, or even interest thereon. Moreover, petitioner's main and limited purpose of entering into the MOU was only to provide financial assistance to defendants, and this fact being recorded at page number 3, paragraph 2 of the MOU. Now, to secure the vacation of interim injunction, the defendant is prepared to immediately deposit with the learned court the entire principal sum at stake to the maximum investment limit recorded with the MOU at the page 3, paragraph 3, that is 1 crore only. Further, the defendant is also prepared to deposit any additional reasonable amount of interest as may be deemed appropriate by the learned court as to overcome the balance of inconvenience between the parties while the suit progresses. The defendant is also prepared to make this remittance directly to the petitioner under the supervision of this learned court, subject to the petitioner demonstrating genuineness of the investment made by him. The petitioner naturally hand over the suit. The petitioner shall naturally hand over the suit property to the defendant it is in an equivalent financial condition, which is the sum of net assets and liabilities. So it is his petition, madam. Now the order is at page 107. Part of the order. Learned counsel for the plaintiff has brought to the notice of this court with the petition that is so and so that in 2022 filed by the defendant on the update, which was directed to be put up on the date fixed, wherein the defendants have proposed to repay the principal amount of ₹1 crore along with the reasonable amount of interest. The learned counsel of both sides. The learned counsel for the defendants has also vehemently submitted the contents of the instant petition, and the learned counsel for the plaintiff has proposed to settle the dispute on receipt of the amount to be calculated through an auditor, which includes contribution made by the plaintiff running to the institution till date. But this is plaintiff has said, this is what the defendant has said. Rather, instead of defendant, it ought to have a plaintiff, it ought to have been defendant. Now comes, my lord, the learned Counsel for the plaintiff also submitted the plaintiff proposed to settlement of a payment of rupees 2 crore 45 lakhs, let this petition be kept in. So it is the process of amicable settlement, which normally nowadays all the cases, the court already makes an endeavor either to conciliation or for mediation or etc. So this has nothing to do with the principle on which the order of injunction to be judged, madam. Now, so far as the fiduciary relationship as it is an MOU, in that case, the issue has to be framed. And it has to be, there has to be a decision that yes, this is not an agreement, this is an MOU, this is on this behalf, etc., etc., etc. But whether this court would like to go into that, which was never a part of the argument, and which still can be trial.
No. This court is entitled to examine whether the trial court is within its jurisdiction.
Yes.
And whether the finding in respect of the prima facie case, balance of convenience and irreparable loss are perverse. So definitely this court can go through the same.
Within this, keeping this while passing the order with the trial court has the order suffers from any perversity.
Pardon?
Now, injunction order is based on the petition filed by me and the objection filed by him. A point which was never raised. Can it be which was never raised before the trial court? But can it be said to be that non-consideration of that point by the trial court himself is a perverse? Or there was illegality? Or
No. Regarding application of the principles
So
of granting temporary injunction.
That's why the first, at the outline only I have submitted, nothing has been said on the principles on which this court would like to interfere with the.
No. Can he not raise the issue before this court?
My lord.
Can the counsel for the other side is not entitled to raise the issue before this court?
My lord, if it is a purely question of law.
Is it not a question of law?
Yes. My lord, it is a mixed question of law and fact.
No.
It's a mixed question of law and fact. My lord, the question of law would have.
How it is a mixed question of law and fact?
Because the evidence has to be laid. Evidence has to be laid to understand the true purport of the MOU and what activities they have taken.
No, that is the business of the trial court.
My lord.
Trial court will examine the same at the end of the trial.
So therefore, my lord, that's what my submission is. So this, the trial court has said.
We are only examining the legality and the correctness of the order.
Yes, my lord. But not on the ground on which, my lord, which was never raised before the court.
No. That I don't think that is correct argument.
But if it is a pure question of law, so far as grant of or refusal of injunction is concerned, in that case, this court will definitely, my lord, look into it, my lord. But here, my lord, what he is submitting, the maintainability of the suit.
No, that may not be appropriate for this court to examine.
But while your lordship will adjudicate that this MOU actually does not confer any right on the plaintiff. That means this suit offense. There is nothing remain to be decided there, my lord. So that is on the merit.
No, that is not the issue before this court now. We will only see whether prima facie case is made out.
Yes. So
whether balance of convenience is in his favor.
That exactly, my lord. Exactly what my lord did, Wanderers Limited also and subsequent other judgment also says, my lord. And therefore, my lord, what I am submitting, my lord, it is an admitted fact that 1912-2018, there is an MOU pursuant to which the entire property was handed over to me to run. I have been running. Because the fact that he was at loss, he could not run it. He has taken a lot of loan from different persons. Everyone is hunting for him. He cannot run. Therefore, he has come understanding with this MOU. It is an admitted. He has also given a special power of attorney, so that I can even operate the bank account. Now, when my lord, I have invested a huge amount, my lord, including repayment of the loan, the school has progressed, school has gained the reputation. Now, you start now questioning, my lord, how much I have involved, I have invested 1 crore, so now I have more than that I have earning for last 7 years, so it should be given back to him. That is what his argument is. So whether this governs by the terms of the MOU, that will be decided by the trial court. But so far as the prima facie case balance of convenience, well, the court has considered that there is an MOU. What is MOU? Is an agreement basically. There is an agreement. Property has been entrusted to him, admitted. Loan repayment.
No. Perhaps there is no clause in the MOU allowing you to run the institution perpetually.
My lord.
By that MOU, you have not been allowed to run the institution perpetually.
Correct, my lord.
Yes.
So, my lord, that has to be, my lord, whether it is under what circumstances this will come to an end. And because
that will be governed by the terms and conditions in
yes,
the MOU.
and because of non-existence of that clause of determination of the relationship between the parties, the document become illegal or inoperative or so, for which he has filed a separate suit. That is pending. That is to be decided. That is suit number 53. If I am not wrong, that is. Yes. For that he has already filed a suit. So that has to be decided. The court will frame issues, laid evidence, under what circumstances the relationship between the parties will come to an end. And ultimately some conclusion court will arrive. Now, presupposing, my lord, that the particular clause is not there, if the entire document is held to be invalid, so that should become in fact, so the relief what he sought in the suit has been granted. The suit I have filed basing on the document on which, my lord, I am exercising my right in operation and the running of the school. That will also become infectious, my lord. It is the injunction is only to preserve the subject matter. What is the subject matter? A school is running by the new managing committee and is doing well. The teachers are happy, the guardians are happy. Complaints between the parties went from here, there to even to deputy commissioner. Deputy commissioner also says, don't interfere with the management of the new committee. So whose interest, my lord, will be affected? That also discussed by the trial court, my lord. At this stage, if the management is changed, but it has also, the trial court also has considered that because of, my lord, insolvency or, my lord, financial, my lord, condition, he could not run the, my lord, school. He has, my lord, mortgaged, he has, my lord, obtained, my lord, loan from various authorities, and including selling of that property to a party whose name is also mentioned in the order. That's for which agreement for sale is also on records. That is his interest on the school, my lord.
No, that is his property. He may sell it, he may alienate it. It is his prerogative.
Exactly, my lord. This will be. I am talking about what I am submitting in reference to the consideration of the grant of injunction or refusal of injunction. What is his intention to sell it to somebody else? So he need to be evicted.
No.
What is the
Here in this matter, the balance of convenience cannot be determined in terms of the submission made by you.
Balance of convenience in this case would be this trial court has also taken note of it. This issue, if ultimately goes in his favor, property will go back to him. This has been considered. I have read out also, my lord. So that's how balance of convenience has been judged. Irreparable loss has been judged. That he is financially already unsound. He cannot run the things and school. I have already invested a huge amount, and school, the teachers and the guardians are happy with the my management.
No.
That is the finding.
That cannot be, perhaps. That cannot be. Anyway, let us adjourn the matter till next week. In the meantime, we will direct the registry to place on record the additional affidavit filed by him. It is not before the court.
And moreover, my lord, here, the injunction is against the trust. My lord, trust was not a party in the MOU. And the injunction was against the trust also. Trust has filed a WS. My line friend said trust has not filed a WS for objection. They have filed, my lord.
I am on record and saying they have not filed.
I shall show. Everything is there. Everything is there.
Okay, you produce, if you have any document to substantiate your submission on next date.
Well,
Heard Mr. Sayola, learned senior counsel assisted by Ms.
Estodi.
Estodi, learned counsel for the appellant, Mr. Soikia, learned senior counsel assisted by Mr. Gupta, learned counsel for the respondent. Heard in part, list the matter on next Thursday.
yes.
Thursday as part heard. In the meantime, registry shall take the additional affidavit filed by the appellant herein with the record. List the matter as part heard.
What? What?
Even for the other side, because petitioner is NSPC. To trouble your lordship, my lord, I'm so sorry to trouble the petition for early hearing this matter. Because the only difficulty is that being the landowners, we are suffering. So can it? So,
Yes.
okay, so my lord, if it is not inconvenient.
Current. I say.
So, my lord, I filed a petition. Why this is urgent, my lord, I just to draw your lordship attention that on 10th of April 2025, your lordship has passed a judgment on 10th of April 2025. This is pertaining to a writ petition which was filed by NSPC along with us in 2020 or awardees of 2018, and thereafter the judgment was passed on 10th of February 2025. Now with the direction setting aside the award of 6/11/2018, my lord, and directed to pass fresh award in accordance with the Lara Act. Now, my lord, thereafter, my lord, we file a contempt, but the period which was given by this court to complete the process for a period of 3 months, they have not done. That's why we came up before this court and contempt notice was issued, and ultimately pendency of the contempt application award was passed on 1/8/2025. Thereafter, my lord, the contempt proceeding while it was going on, my lord, on 16th of February 2026, my NSPC filed a writ petition before this honorable court, which is 58 of 2026. Now that was moved on 18th of February 2026, my lord, and the order that has been passed, your lordship has gone several times of the order. I don't want to repeat that order which was passed. There is some consent, the order which was passed while passing the judgment, and ultimately, my lord, the court said, okay, we'll issue a notice, but subject to condition that you have to deposit that account. So the amount of 48 crores was deposited before the registry of the Arunachal Pradesh High Court. Now, my lord, thereafter, the contempt application was heard by your lordship, and the contempt application was moved before this court, and on 1/4/2026, my lord, contempt was heard and CAV. It was CAV with my lord. We filed an application for IA for disbursement. So, but in the meantime, if your lordship kindly see 1/4/2026 order at page 41. So 9th of March, we filed all the replies because it was directed by the court on 9th of March to file reply affidavit in opposition to the writ petition. Accordingly, we have filed. And in the meantime, on 1/4/2026, my lord, at page 41. Please see, my lord, 41. On 1/4/2026,
art so and so. Argument in to application conclude result. Naya learned counsel anyway submit. He will file one rejoinder affidavit. And if there is for granting in 2 weeks time, prayer is allowed. List this matter on 2026. And at page 45, the matter was again listed on 29/4/2026. And please see my note. Again, they sought some time. So they filed rejoinder on or before 29/5/2026. And thereafter, my lord, they filed and my lord, and for page 49, at page 49, has agreed, raised this matter on 3/6/2026. So my learned friend Raju, my lord, your lordship just recollect, he said that some matter in the Supreme Court also will get closed. So the matter was fixed on 3/6/2026, my lord. But on 3/6/2026, when the matter was listed at 2 o'clock, it was mentioned before the court that here's some matter for the Supreme Court, so matter may be adjourned after vacation. So your lordship has fixed the matter on 14/7/2026. Now 14/7, we have been learned at 14/7/2026. By lord, the Arunachal Pradesh courts are closed. Now, can I just make one humble prayer before this honorable court, my lord? It is not inconvenient to your lordship, my lord. My lord, the rejoinder or everything is complete. So 158 is concerned. We have filed an application for maintainability of the maintainability. We have taken the point of maintainability. State is also have taken the point of maintainability. If it is not inconvenient to your lordship, my lord, can this matter can be fixed for hearing the maintainability from our side first, my lord? If it is not inconvenient to your lordship. Not today, my lord, by next week, if it is possible. Because your lordship is away. Your lordship is saying that your lordship will not be in the station. If it can be fixed, if it is not inconvenient, my lord.
Yes, who is appearing?
I am, my lord. I am appearing
Vidyanagara
for
bench?
NHPC, my lord.
Pardon?
I am appearing for NHPC, my lord.
NHPC?
My lord, yes, my lord.
Okay, you have received a copy of this application?
Yes, my lord.
What is your stand?
My lord, first and foremost, I apologize for mentioning the matter on 3rd of June without the consent of London Senior Counsel, my lord. Now, my lord, Learned Additional Solicitor General Mr. S.V. Raju will be available only after 29th of June, my lord. That is the difficulty, my lord. So, my lord, any date after summer vacation would be convenient for our side, my lord.
Can I just suggest one thing to my learned friend's reply? Because as I have to start so far as the maintainability, point of maintainability, I can start there, my lord, next Monday. He can note down, my lord. At least one day I require, my lord, for maintainability point. Then thereafter, state government has also taken a stand on maintainability point. So if your lordship here, then your lordship, they can give a reply to maintainability point and on the merit of the case.
Yes.
So on Monday, the matter can be taken up at 2 o'clock. If it is not, my learned friend can note down. Thereafter, my learned friend give a reply thereafter. We have
Difficulty,
taken the point of maintainability, my lord.
Yes.
My lord, difficulty is I have been only instructed to inform this court that Mr. S.V. Raju will be only available after 29th of June, my lord. So he has instructed me to make a request for listing of the matter after summer break. Though the award is under challenge, my lord, we have already deposited the amount in the registry of the Honorable Court.
Yes, but you have not deposited the amount in the contempt petition.
Yes, correct. Right.
You have deposited the amount in the
writ petition.
Writ petition.
Yes, ma'am.
If you have no objection in the event of releasing the amount in the IA, then we can do it.
Yes.
Whether that instruction is available with you.
No, ma'am. As on today, I have no instruction.
When this matter be listed on this Monday, let them take an instruction. Then if they can release
they can deposit in the account of deputy commissioner so that it can really, that will be subject to the outcome of the writ petition. At least we will not suffer, my lord.
Okay, that was the submission of Mr. Raju on the other day also,
Yes.
that they have deposited the amount. Now you obtain instruction that whether we can release the amount in the contempt petition.
Yes, my lord.
So
Okay.
can we hear the matter on Monday?
Monday at 2 o'clock, my lord.
My lord, on Monday, so far instruction, my lord, I will get the instruction whether that amount can be released or not.
On Monday, you can obtain the instruction.
My lord.
But in respect of the suggestion of Mr. Das regarding hearing the petition on the point of maintainability.
My lord, I will convey that suggestion to Mr. S.V. Raju, and my lord, I will inform this court on Monday.
Monday. Okay. Heard Mr. Das, learned counsel, senior counsel, assisted by Mr. Learned counsel for the applicant. And Mr. Your name, please?
R.L. Thungan, my lord.
R.A. Thungan, learned counsel for the NHPC.
NHPC, my lord.
NHPC. The petitioner in WBC number 58 of 2026. This application is prepared by the applicant for preponement stroke early hearing of the writ petition number 58 of 2026. Mr. Thungan, learned counsel, appearing on behalf of NSPC, submits that Mr. S.B. Raju, the learned additional solicitor general of India, will be available only after
29th of June, my lord.
29th of June. 29th of June. And he also submits that the award in the WPC number. What was the number of the earlier WPC?
The earlier WPC was 242.
242
of 2020.
2020.
230 of 2020.
The compensation amount has already been deposited before the registry of this court.
Yes.
However, it appears that the said amount was deposited before the registry of this court, registry of the court, in respect of the writ petition civil number 58 of 2026, not in the contempt petition. In that view of the matter, Mr. Thungan is directed to obtain instruction as to whether the aforesaid amount can be released in connection with the contempt petition number. What was the number?
Contempt petition, my lord, 15 of 2025, my lord.
15 of 2025. 15 of 2025. Further, Mr. Thungan shall obtain instruction regarding fixing the matter, regarding initiation of hearing of the matter on Monday, 15th of June. No, sorry, 8th of June.
Yes.
8th of June at 2 p.m. Registry shall list the matter on 8th of June at 2 p.m.
The point of maintainability.
Pardon? On the point of maintainability of the writ petition.
And deeply obvious, my lord.
Obvious, my lord.
Deeply obvious.
That is pending trial.
Deeply obvious. Pending items. Item number 30.
Today.
Just now, we have received the affidavit in opposition.
Okay. Heard Miss
S.A. Khalifa.
learned counsel, appearing on behalf of Mr. M.S.A., learned counsel for the applicant. Ms. R. Devi, learned CGC for the respondent number 2. And Mr. Bhattacharya for respondent number 1. Respondent number 1.
Respondent number 1.
Okay. Ms. Devi submits that she has filed the objection today today. And accordingly, it is provided that rest will list the matter on Tuesday or Wednesday.
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 Okay.
Wednesday.
31 is similar.
Rest shall take the take the objection petition along with this IA. Along with the IA. Yes.
I'm also paying for exponent one. Number 5, submission.
It please, Lordship. Lordship, in compliance with the order dated 9/2/26, we have filed additional affidavit, Lordship.
Okay. Heard Mr. Talukdar, learned counsel for the appellant. Pursuant to order dated 9/2/2026, Mr. Talukdar has placed on record the FIR over Ratabari PS case number
20 of 23, Lordship.
20 of
23, 20 of 23, Lordship.
20 of 2023. 20 of 2023.
Lordship, neither accident information report nor FIR has been forwarded by the concerned IO to the Planet Tribunal.
Forwarded.
Neither accident information report nor FIR has been forwarded to the Planet Tribunal by the IO. So my prayer is that Planet Tribunal may be directed to call for the accident information report and FIR and treat the same as claim petition and further proceed with the case as per law. In similar case, you will have to pass order, Lordship. I have submitted the same. No, I have a copy, Lordship. 11 part is at page 5, last page, paragraph 11.
Okay, we'll pass the order.
Lordship, obliged.
Number 6.
Appellant is absent. None appears for the appellant on call. However, Mr. M. Ahmed, learned counsel for the respondent present.
He has also not furnished us any memo papers. Because the matter is getting delayed, so we made a mention for listing this matter. It's on our mention.
Whether name of the counsel is reflected in the cause list. People. It appears that on 6/5/2026, when the matter was listed, the appellant remained absent. And on 28/4/2026 also, the appellant remained absent without step. In that view of the matter, this court is inclined to dismiss this appeal for non-prosecution. In view of the order passing this MSC appeal, the IS civil number 4180/2025 also stands dismissed.
Item 7.
Page number? Your present here to mention. The heated you, it up and yet. I will do some consultation like here. May I please your lordship? This is a matter, now, today is for maintainability. Wait, this issue. This application is filed under Section 37 Arbitration Conciliation Act. Now what 37 says, my lord, I'll bring on that report. My lord. This is appeals. Lordship got it right.
Yes.
Here, my lord.
Okay.
The issue report is going to maintainability. This award passed by, this is that land was acquired by the National Highway and the National NH Act, my lord.
Excited. Yes.
That NH Act, under provision of NH Act, it was this one. When this one award is there, not satisfied with compensation, they approach the learned arbitrator who is appointed as per by central government, as per NH Act 1956, my lord. This award is been challenged before it is district civil judge, now it is a competent authority. Now it is been district civil judge senior division, my lord, under section 34 of the
Arbitration and Conciliation Act. That is an application. There is an application is filed. That they have challenged here, page number. If we go page 29, their application there is Lordship, annexion number 2.
Page number?
Starting from page number 29 of my
29.
appeal, Miller.
Yes.
That is starting from now. There, this application is an accept to Miller, which application filed before the Daniel, the Honorable District Judge. Now it has been seniors, civil judge, senior division. Now if you go, Miller, by Lordship will, their prayer, my lord, will go by this. Because question of availability will come, my lord. That is why I'm bringing on this record. Because as per Supreme Court judgment, that question will come later on. That is why. This 44, my lord. Lordship got it. Lordship got it. May I read, my lord? Prayer only. In the premises, suppose it is prayed that your may be pleased to, admit this application call for records of the tribunal after hearing the parties be pleased to set aside impinging award 2022 passed by the Learned Commissioner, Lower Assam Division, arbitration number so and so. Decision thereby further be pleased to enhance the award as per the report stated 26/4/2011 and 3/12/2011 to the tune of 7,34,50,000 with interest 18% till realization of which effect January to say and or be pleased to pass such orders. Your honor may be deemed fit to proper PI. Here, my lord, entire award is being challenged here to set aside. That been set aside. Under section 34 clearly says this to be set aside. And this prayer only set entire set aside. It is there. Now, my lord, during pendency of this application under section 34, they filed an petition. That is a petition which is for releasing amount of 73 lakhs. I saw that amount. According to them, it is not disputed amount. That is the issue here now with your lordship. Now, why then the learned court below was pleased to grant to release the 73 lakhs. Now I am before your lordship under section 37, provision of action. That is an interim measure. First question will come whether section 34, any interim measure on 100 provision will be there. That is also question is coming. Now any interim measure is coming 37 will say 37, sorry. Here. Appealable orders, notwithstanding anything contained in any other law for time being in force, an appeal shall lie from the following orders and from the court authorized by law or to hear appeals from original decree or pass court passing the order, namely refusing to refer the parties arbitration under section 8, granting or refusing grant of interim measure, granting or refusing to grant any measure under section 9, setting aside the refusing set aside arbitral award or appeal shall lie from the court and order of the arbitral tribunal. And then next will come accepting the clear report to this section 2 of subsection 3 of section 16. B, granting or refusing grant interim measure, section 17. No second appeal shall lie. Here now, I am coming under interim measure because first and foremost thing, Now we have to little bit go back because last day my learned friend just shown that a Supreme Court judgment, constitutional bench judgment. I have also gone through this, but here question have come severability. Which portion can be separated? That can be, but here the question coming, my lord, entire arbitral award has been challenged. If severity means generally, suppose what I am understanding my limited knowledge.
No. 37, no, 34 application was filed by them for enhancement.
No, there is a no, because enhancement provision is there that they're setting aside. First, the application, Lordship may, for this one will go section 34 what says. 34 what will say. That is the main question before Lordship now. Application for setting aside the arbitral award. That is setting aside, not for here enhancement. Enhancement, because it is section 34 clearly says that recourse of the additional administration or award may be application setting aside. Here clearly says, my lord, setting aside. You have to set aside. This is for setting aside. The entire award to be set aside. Thereafter, if he enhances there, that is to be remanded to the arbitrator. This court has, lower court has no, I have not seen middle of my maybe limited knowledge, limited. There is no provision for enhancement. This court cannot enhance the provision. That is clearly says 34, the setting aside. No way word is there enhancement. They cannot. Court below doesn't have power, I think. It can be set aside. And their prayer also, it is clearly says this is for setting aside entire award. They have, if severability would have also come time being waived for assuming not admitted, that if wouldn't pay for this portion, whatever portion is there, 73 lakhs that we paid for further enhancement. It is not. It is for setting aside, my lord, entire award. And award cannot.
No. You come to this page number 44, the pair person. No pair is there for setting aside.
This did section 34 itself for setting aside, my lord. Applications filed under section 34 itself setting
Okay.
aside.
Yes. The pair is there for
Yes,
setting
my lord.
aside. Set aside the
If it is
award.
not also, my lord, 34
Award.
clearly says this is for setting aside. And the question of severity will come if it is can be separated. Here, lordship by a prayer, their entire setting aside, then the award day enhancement they want 7 crore 34 lakhs. But now this one question will come without setting aside. Without setting aside cannot be. Even timing assuming also. But that cannot be. It has to be set aside first. Because section 34 clearly says, my lord, that is for setting aside. No way enhancement. That is why my lord, my humble prayer was before the learned trial court also. Now also this same prayer I will make. This case has been kept for, record is not received, last order we say, record is not received, fixed for hearing. The entire maybe can be hard. Whether severity will be there or not, whether what portion will be there, this will be decided by a court below. If it is be separated, that will be separated by this. This entire matter can be heard, but into why intent measure? Under what provision? That is also only question of me before us, my lord. That is why entire matter may be heard, the direction may be passed because already lower court, it is only said the last order, lower court received, not received. Clearly says that order. You pay in the meantime. That lower court record comes and in the meantime, entire case may be heard. There is no further intent. Ambiguity or decision. This entire may be heard. Whether that Supreme Court judgment will abide by or not, will be applicable or not, that will be decided during trial. Because severability, what portion will be kept, what portion will be taken away, that is to be decided by the lower court below. Court below. My humble prayer, I am not against of this. Today, entire may be heard, get finished up. The lower court record is called for. we would have waiting for long decision, this filed in. কেটে ফাইল করেছিল এটা ডেভেলপার কেটে ফাইল করেছিল এই অ্যাপ্লিকেশন স্যার কেস নাম্বার it is filed in 22 itself, my lord. Now, last stage, it is even it is not admitted. I have not been allowed to file objection. It is not this one. That is the lower court record is called for. After coming lower court record only, I can also put objection.
Mr. Borua,
My lord.
you say regarding this amount, you have no objection.
No objection. No, I hear me, lord. Today, I cannot say I don't have objection, but as per law, I have to go. If it is, but cannot be separated now by interim order, my lord. My prayer is this one. And entire matter may be heard. The court, lordship passes specific order because already record is called for. I may be also given an opportunity to defend the case. So far, I have not, because it has not been admitted so far. Record is not called for. That time within weekend 22, we are waiting, my lord. I can be, entire procedure will be completed within the limited period. We can finish the entire matter. Now my learned friend is telling the severability. What Supreme Court says? Severability, that severability meaning itself, I have also seen lordship also aware. What portion can be separated? Severability means two awards. Suppose of understanding, some award is passed as A or some other portion is as a B. If both are can be separated, what portion and invalid portion? This will be decided. What's the valid portion? Then only. That is to be decided. Here, it has to be decided first. I have no objection means it is, I am not challenging. Only not objection means it's not that. It is according to law decision code below that I have not challenged. Yes, I have not challenged. Because when I wanted to go for challenge, already under challenge of by them. Before coming, they have challenged for setting aside. This entire matter may be hard. That is why I have not gone for challenging. Now, that is the question will be decided by the court below. Because they have only filed, it will be severability, it will come. Now, my humble prayer before lordship, the entire matter can be heard within a span of short time. Then matter gets finished. Then suppose it is severity part will be also
No,
decided.
for how long it is pending before the trial court?
No, because already last order, yes.
Last 3 times they have taken time for producing record.
Producing record means, my lord.
Whatever my.
No, learned friend, let me wait.
Not gone to section 36.
No.
That is, it will clarify all my friends.
My lordship, one thing may be there. Record, can I bring records, official records? It is the court, honorable court to ask for records.
I asked for 4 times.
4 times, 5th time, there is the court. I cannot bring the records. That is not my fault, my lord. I cannot bring the records. It is the court. What manner it is brought. Suppose it is not their provision of law, they can send any manner.
No, Mr. Borua, you cannot take that stand.
No, that stand I'm not taking. He is taking. Court, lower court records is being called for by the learned.
No,
court
since you are representing the department, you can bring the record.
No, how? Because record is with the arbitrator, my lord, not with me. Because it is with arbitrator. What happened? Why got delayed, my lord?
After passing the award, where is the question of retaining the record by the arbitrator?
Yes, that is with arbitrator. Because it is the arbitrator. What happened? Why it got delayed, my lord? Earlier, Lower Assam Commissioner was the arbitrator for this. In the meantime, it is got changed by notification. Now it is in dispute. Now that is lower arbitrator. This record with the arbitrator, not with me, my lord. It's I am NSCI doesn't have. Cannot keep also record. This is arbitration record. That entire maybe. And my learned telling is that another point is coming up. He will bring I'll 36. Where is where they have mentioned? Where execution, where they have gone? This word wrongly, it is written execution. What? Which application they have filed under 36? Yes. If would have been 36, then would have been entire scenario would have been changed or separate. They have not filed any application. 36. Whether application 34 filing application under section 34 can be treated as a 36? No. This is a separate provision. They have not filed execution case. Fine, that is a humble prayer. This, of course, Lordship satisfaction. It is my kind of submit only. This entire matter may be hard because that is the court below has to, because I cannot bring the record open this thing because that is arbitrator already.
Now the record is available.
Oh, yes, available with the arbitrator. That
No, record has not reached the trial court now.
No. They have called, if it was called government advocate also, they are representing their, then their court is with the arbitrator now. If suppose he is telling no, that means can I keep court's record with me, my lord? This is just like court record. Suppose this is arbitration, means arbitration result of one court, arbitration proceeding tribunal. Can I keep this order with me, being one of the parties? Can he keep? No, certainly not. It is the court with the tribunal is the record. It is with the tribunal. Like this our court. This all records are with this honorable court. I cannot give. Because this entire record is this one. I don't have, my lord. It is why record was called for. Record may be the way means, because court can very well call any means, my lord. They can, I cannot bring this one. But I have assisted only by saying that earlier 2 occasions court has honorable.
No. Mr. Borua, you see, today is fixed for hearing on the point of maintainability of this application.
Here,
Now
that
the
is why.
question is whether in the event of non-maintainability of the petition, we can direct the trial court to hear the matter.
Yes, my lord, it is a maintainable, very much maintainable under section 3B. Any interim measure, that is the interim measure only.
No.
There is an interim measure. If he is saying no, that means he is satisfied with 73 lakhs. If it is not interim measure, my lord, I am assuming this one, he is paying for 73 lakhs out of, but whereas he is claiming for 7 crores.
Okay, Mr. Borua, according to you, this application, this appeal is maintainable.
Maintainable.
It is your submission.
Yes, my submission.
Yes, what is your submission?
This is an application by him under section 37. 37 says, if there is a refusing to prefer the parties to arbitration, if they go for civil suit, section 8 says there is an arbitration clause. If the court refuses to refer to the under section 8, then 37 will come. In before a arbitration case, before, during or after, I can file for an injunction under section 9. Then 37 applies. Setting aside or refusing to set aside arbitral award, the final award against 34, then it will come. Then before the arbitration tribunal, section 17, 37 will come. But not against that interim measure of 36. Your Lordship, I just kindly request Your Lordship to look into section 36. Admitted fact, they have not gone for appeal under section 34 against the award. So enforcement. Where the time for making an application to set aside the arbitral award under section 34 has expired, then subject to the provision of subsection 2, such award shall be enforced in accordance with the provision of Code of Civil Procedure in the same manner as it be through a decree of the court. Where the application to set aside award has been filed in the court, of the filing of such application shall not by itself render that award unenforceable, unless the court grants an order of stay of operation and the said arbitral award accordance with the provision of subsection 3 on the separate application made for that purpose. My lord, after filing an application for stay of operation, the court may subject to such and such. So that provision they have not done anyway. And 36(2) says, filing out of a 34 application proceeding aside does not make that, I cannot file an application for my interim award. That award has become finality. They have not gone for 34. If I have gone also, my friend's argument, if I've gone for also, my prayer in my application is there, that's not setting aside and enhancing the application, enhancing the amount. I made an interim prayer in 34, but interim prayer cannot be granted by the court. So I filed an application that is at page 56 to release that amount. And after hearing both the parties, the court has allowed the award because they have not gone for 34. They have never applied. And this Supreme Court Constitution bench has said that 34 and 37 can be similarly done. So this portion, which is admitted fact, can be provided to me. That balance portion, if enhancement, that will be looked into by the court. This portion, nothing has to be wrong is there because they have not gone for 34. Under 36, I can make, and if at all they should have come before this court against this order, 227 would lie, not 37. 227 is lie. Because 37 invariably cannot lie. Section 8 is not there, section 9 is not there, final award of 34 is not there, section 17 is not there. So where is the scope of 37? The court has specified, the legislature has specifically laid down either in section 8, section 9, section finality of 34 and in section 17. This only 37.
Okay, okay. Heard Mr. Borua, learned counsel for the appellant. Mr. Roy Soduri, learned senior counsel, assisted by Mr. learned counsel for the respondent. Argument on maintainability of the petition. The appeal is concluded. Order reserved.
My lord, obliged.
Number 8,
Malad, may I please, Your Lordship?
Yes.
Sir, this is a first appeal, Malad, against the judgment dated 2023 to 2026.
Yes.
The first appeal we have preferred against the judgment dated 23 to 2026 at page 99, Malad. But we are aggrieved by the judgment on various grounds. And my learned friend is on caveat appearing for the other side. At this stage, Malad, I would pray that Lordship may kindly admit the matter and call for the LCR, Malad.
Okay. Caveat is disposed of?
Yes. Lordship.
Put this in there. Okay. Caveat would be heard. Caveat is the discharge. Heard Mr. Dinner, learned senior government advocate. From standing counsel PWD for the appellant and Mr.
G. Khandelia.
G. Khandelia, learned counsel for the respondent.
Sole respondent.
Sole respondent. This appeal under Order 41, Rule 1 and 2, read section 96 of the Code of Civil Procedure is directed against the judgment dated 23rd of February 2026, passed by the Learned Civil Senior Division number 3, Kamrup M. Gauhati in MS in money suit number 313 of 2018. It is to be noted here that by the impugned judgment dated so and so. Whether decree was passed, Mr. Nath?
No, Malad. Decree we have prepared, decree we have applied for, certificate copy we have applied. It is not yet prepared.
Okay.
We have already applied for the certified copy.
Appeal is usually against the decree.
Judgment and decree, but the period of limitation will run. They will prepare the decree and sign the decree at the back date. Ultimately, the period will be over by that time. I have submitted in my petition, Malad, we have said paragraph 3 at page 8. We have stated, Malad, page 8, para 3. That at the time of filing of the instant appeal.
No, Mr. Nath, you say section 98 provides appeal from original decree. Here decree is yet to be passed.
Well, that's true. That's true, Malad. That's true.
Then
We have not yet filed our execution petition. So it may
No.
be taken after 2 weeks.
kindly consider one thing, Malan. The decree they will prepare, it is a process. We have already applied for the certified copy. It is a process undertaken by them at office. They will prepare the decree and sign the decree at the date when the judgment is passed. Then, Malan, the limitation period will be over by that time.
No, because no, only in order to save the period of limitation, this court cannot go against the provision of law. Mr. Nath, you say
Logic,
96
logic.
is clear against the
Logic.
original decree. Here, decree
True.
is not challenged.
True.
You are challenging the judgment.
Logic.
Mr. Nath, you say you
Malan.
are aware of the decision of the Privy Council, Taylor versus
Logic.
Taylor and Nazir Ahmed.
Logic. True, Malan, true. Then kindly.
So suggest me what to do.
Then Lotte may kindly keep it after 2 weeks, Malan. We have already applied for this degree, Malan. The moment I get the degree, I'll file an additional affidavit here, Malan.
In both the provision, Mr. Nath, in order 41, rule 1 and 2 also, it is from original decree.
Decree, Malan. That's true. Absolutely, Malan. That's true.
Right, impugn judgment dated so and so, the learned civil judge senior division number 3 has decreed the suit for recovery of a sum of rupees 87 lakhs 48,444. To a pointed query of this court, Mr. Nath, learned senior counsel, learned senior government advocate for the appellant, submits that this appeal is directed against the judgment dated 23rd to 2026, and the decree is not yet prepared by the learned trial court, and as such, the same could not be challenged in this appeal. However, Section 96 and Order 41, Rule 1 and 2 provides that appeal will lie against the original decree. Under such circumstances, Mr. Nath submits that he may be granted 2 weeks' time to bring on record the decree passed by the learned civil judge senior division number 3 Kamrup M by filing one affidavit. They are allowed to place the matter after 2 weeks.
Malan, highly obliged, Malan.
Your Lordship, this present MSA appeal is filed under Section 173 of the MV Act. Your Lordship, we have come before this honorable court for enhancement of the judgment and award passed by the learned member, Motor Accident Claims Tribunal number 1, Your Lordship.
Heard, Mr. Iqbal, learned counsel for the appellant. This appeal under Section 173 of the MV Act is directed against the judgment and award dated 27/2/2026 passed by the learned member, Motor Accident Claim Tribunal number 1, Kamrup M, Gauhati, in MSC case number 668 of 2020 for enhancement of the award.
Yes, Your Lordship.
Peruse the memo of appeal and the grounds mentioned therein.
Page
and
number
also
4.
Peruse the impugned judgment and award dated 27/2/2026. Admit issue notice to the respondents returnable in 4 weeks. Shall be taken by speed post and also by usual process within a week from today. Rest is call for the record from the learned tribunal is the matter after 4 weeks.
Deeply obliged, Your Lordship.
Item 10.
May please your lordship, it is the matter of enhancement of awarded amount.
Enhancement.
Enhancement, your lordship.
Okay. Heard, miss, your name, please?
P. Bordolo. P. Bordolo.
P. Bordolo, learned counsel for the appellant. This appeal under Section 173 of the MB Act is directed against the judgment and award dated 21st of February 2026, passed by the learned member, Motor Accident Claim Tribunal, Sunitpur, in MSC case number 22 of 2024, within bracket injury. filed under section 164 of the MV Act. Where is the memo of appeal and the grounds mentioned therein, and also where is the impugn judgment and award dated so and so. Admit, issue notice to the respondents, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Justice shall call for the record from the learned tribunal, list the matter after 4 weeks.
Lordship, next matter is same, Lordship.
11.
Amendment of award
11,
amount,
10.
same Lordship.
Okay, okay,
Bless.
same order.
May I appeal, Lordship? Lordship, we prefer the appeal, my lord, on the ground of quantum, my lord.
Heard Ms. Sharma, learned counsel for the appellant. This appeal under section 173 of the MV Act is directed against the judgment and award dated
27, no. 18 to 26, my lord.
18 February 2026, passed by the learned member, Motor Accident Claim Tribunal, Goalpara, in MSC case number 433 of 2022. It is to be noted here that by the impugn judgment and award dated so and so, the learned tribunal has directed the appellant herein to pay a sum of rupees
64
lakhs
15,000.
15,000, being the compensation to the respondent herein. Where is the memo of appeal and the grounds mentioned therein, and also where is the impugn judgment and award dated so and so. Admit, issue notice to the respondents, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks. Rest shall call for the record from the learned tribunal.
Obligation, my lord.
Aye.
I lord, my lord, let them appear, my lord.
Okay. Heard Miss L. Sharma, learned counsel for the applicant. This application is preferred by the applicant for staying operation of the impugn judgment and award dated 18/2/2026. Passed by the learned member, Motor Accident Claim Tribunal, Goalpara, in MSC case number 433 of 2023. Ms. Sharma submits that this IA may be considered on appearance of the other side. Accordingly, it is provided that Justice shall list the matter along with appeal number 294 of 2026.
Obligation.
There is an appeal against the judgment passed by MSAT 1, Lordship. There is an appeal preferred by the insurance company.
MSAT 1 of who is district?
Kamrup Metro, Lordship.
Kamrup Metro. Heard Mr. P.J. Borman, learned counsel for the appellant. This appeal under section 173 of the MV Act is directed against the judgment and award dated 1/4/2026, passed by the learned member, Motor Accident Claim Terminal number 1, Kamrup M, Gauhati, in MSC case number 1487 of 2023. It is to be noted here that by the impugn judgment and award dated so and so, the learned tribunal has directed to pay a sum of rupees 23,57,300 rupees with interest at the rate of 6% per annum. Per annum on 17 on a sum of rupees 17,63,300, excluding the future prospect from the date of filing of the claim petition till realization. Where is the memo of appeal and the grounds mentioned therein, and also where is the impugn judgment and award dated so and so. Admit, issue notice to the respondents, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Rest shall call for the record from the learned tribunal, list the matter after 4 weeks. IA?
IA is dear, Lordship.
Should we dispose of the IA?
Lordship.
Heard, Mr. Is a Burman Learned Counsel for the applicant. This application is prepared by the applicant for staying operation of the interim judgment and award dated 1/4/2026 passed by the member motor accident claim terminal number 1 Kamrup M in MSC case number 1487 of 2023. Mr. Borman submits that the connected appeal has already been admitted by this court. And the record has also been called for. And in that view of the matter, there is a requirement of staying operation of the interim judgment and order date award dated 1/4/2026 till disposal of the MSC appeal, connected MSC appeal. Madam. In view of the submission of learned counsel for the applicant and also considering the fact that the connected appeal has already been admitted for hearing and the record has already been called for, this court is inclined to dispose of this petition application. Staying operation of the interim judgment and award dated so and so, subject however to the condition that the applicant stroke appellant shall deposit 50% of the awarded amount before the registry of this court within a period of 4 weeks from today. In terms of this, I stands disposal.
Lordship, notice to respond number 226 may be waived because it seems that 225 are the minors and 6 the father of the deceased. The same family
Okay.
member. Lordship.
Mr. Borman, however, submits that respondent number
6 Lordship.
226 are minor.
No, 225 are minors and 6 is the father of the deceased. All
2
are
to
same
5
family.
are minor and as such notice on their behalf may be served upon the respondent number 6.
One.
One.
Obliged, Lordship.
Item 14.
May I please, Your Lordship?
To notice on their behalf notice in respect of the respondent number, so it's shall be served upon respondent number.
May I?
Yes,
Lordship, this appeal has been prepared for enhancement of award, Your Lordship.
enhancement. What was the amount?
Amount was 8,21,183, Your Lordship. Passed by the learned member number 3 MSCT of Kamrup Metro, Your Lordship. In order dated 11/2/2026, passed in MSCT number 18/29/2020.
38 lakhs.
Lordship, 38 lakh, but after deducting award has been awarded 8,21,183 at page 44, Your Lordship.
Heard, Mr.
Yes, I Akan.
Learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and award dated 11/2/2026 passed by the learned member motor accident claim terminal number 3 Kamrup M Gauhati in MSC case number 1829 of 2020 for modification and enhancement of the compensation amount. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and award dated 11/2/2026. Admit issue notice to the respondents, returnable inquiries that be taken by speed post and
Lordship,
also by
may I
visual
submit?
process.
Lordship, there is a sole respondent and learned counsel is there, so I may allow to dusty service. Allied matter also, item number 16.
Number 16, I filed an appeal in this case, Lordship, for an engineering assurance company Limited, challenging the quantum award, and they have filed also
For an issue.
enhancement, Lordship.
Item number 9. Oh, no, we are taking
14
item
and
number
16,
14
allied matter, Your Lordship. Item number,
Item number 16.
today.
yes, Lordship.
Arising out of the
Same judgment
Same
and
judgment.
Yes,
award. Okay, order pass করলি?
So I can again for the response.
Okay, all right.
Justice.
However, Mr. K.K. Bhatt, learned counsel for the respondent, entered appearance and received notice, and as such, no formal notice is required to be issued. However, extra requisite copy of the memo of appeal along with the impugned judgment and award be furnished to Mr. Bhatt during the course of the day. List the matter after 4 weeks. This is a call for the record from the learned tribunal.
Deeply obliged. 16 to 30.
Lordship, in this case, we have challenged the quantum of award, Lordship.
Heard Mr. K.K. Bhatt, learned counsel for the appellant, Mr. Learned counsel for the respondent. This appeal under section 173 of the MB Act is directed against the judgment and award dated uh, 11 to 2026 passed by the member, learned member, Motor Accident Claim Tribunal number 3, Kamrup M. Gauhati in MSC case number 1829 of 2020. Where is the memo of appeal and the grounds mentioned therein? Also, where is the impugned judgment and award dated so and so? Admit issue notice to the respondent. Returnable in 4 weeks. However, no formal notice is required to be issued since the respondent is represented.
Respondent number 1.
Respondent number 1.
Yes. And
Two
respondent number
two is there.
We go. Two is there. In item number 16.
Since Mr. So-and-so entered appearance and received notice on behalf of respondent number 1, no formal notice is required to be issued. However, extra requisite copy of the memo of appeal be furnished to him during the course of the day. Step upon respondent number 2 be taken by speed post and also by usual process within a week from today. List after 4 weeks. Let's call for the record from the learned tribunal. There is MSC appeal number 298 of 2026 be tagged with the MSC appeal number
296 and
296 of 2026.
I for the stay, Lordship, will deposit 50% amount, Lordship.
That amount was
One caveat is there. Caveat or we heard. Caveat is this service. Heard Mr. Bhatt, learned counsel for the appellant, and Mr. So-and-so, learned counsel for the respondent. Number 1.
Yes, your last. Respondent number 1, claim.
2 is driver.
Driver come owner.
Driver come owner. This interlocutory application is preferred by the applicant for staying operation of the impugned judgment and award dated 11/8/2026 passed in MSC case number 1829 of 2020 by the learned member, Motor Accident Claim Tribunal number 3, Kamrup M. Gauhati. Mr. Bhatt submits that connected MSC appeal has already been admitted for hearing and the record has been called for, and as such, the impugned judgment and award is required to be stated, and the appellant is ready to deposit 50% of the awarded amount. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the fact that the connected appeal has been admitted for hearing and the record has been called for, this court is inclined to dispose of this petition. No, inclined to allow this petition, subject however to depositing 50% of the awarded amount before the registry of this court within a period of 4 weeks from today. On such deposit being made, the respondent number 1 will be at claimant will be at liberty to withdraw the same, subject however to proper identification.
Yes, sir.
No, nine.
15.
None appears for the appellant on call, lays the matter after a week. In the event of subsequent non-representation, appropriate reversal follow.
Against 45. Pardon me.
May I please worship? I have appeared on behalf of Arsidas.
Pardon?
On behalf of Arsidas. The English counsel is unable to appear.
Today you have to leave for the personal meeting.
Okay, all right.
I've checked the judgment, it will not be covered, man. That one judgment, coordinate bench judgment he has placed by on last occasion. That perhaps will not cover. There we have admitted that the dice data of 2019 is available. But there was some anomaly in the dice data. Fault of the authorities. On that line, honorable court, it will have to be given.
Okay, let him remain present.
Anytime on next.
As agreed by learned advocates of both the parties, recess and lays the matter on. Okay.
Next week, anytime convenient.
Next week.
Okay, next.
Last day.